and they're all well aware that Maine is in the top per capita. Somewhere around 9% of the population are veterans, civilian population, just because of our low total population. So we're like in the top 3% per capita across the country of veterans. So it's just, they knew that right off the top of their head, that the veterans in Maine. So
Well,
if there's any veteran members on the committee, I welcome you to, and we're actually contemplating opening it up to non-veterans too. So, but that's something the committee has, the caucus has to decide on.
It's good work, Jim. We had a bill, I think it was before you were on our committee, about allowing veterans to be excused from jury duty if they wanted to.
Yeah.
With their service, would have eliminated 11% of the jury pool.
And we were not in favor of that, just because, you know, I think it was well intentioned, but you know, veterans typically have that approach of, you know, we're here to serve and we're here to do what we can, not to dodge or duck or get out of anything. So
we heard that.
That one didn't go over very well in the veteran caucus. Sure, like a lot of others, it was constituent, probably based, and
it
well.
Yeah.
It was well intentioned.
Yeah.
It had to do with folks having difficulties, but there was a mechanism for that already in place.
Yeah.
Representative Libby is stuck in the attendee room. So if somebody could move her over. Oh, no, she's here in the waiting room. I'm not sure. Oh, we'll come on for votes if able.
I think all of us are gung-ho about jury duty philosophically until we get the call.
I've never been called.
Good morning, everyone. It looks like we have a quorum. We definitely have a quorum. So let's begin our first Friday morning of work. We have a whole bunch of work sessions today. We're gonna begin our work now and work until 12:30 and make as much progress as we can. We will start with our usual committee introductions and then move into the work sessions. So let's see, Representative Thorne, let's start with your introduction.
Thank you very much, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a small portion of Etna up here in beautiful Penobscot County.
Thank you. And Representative Evangelos?
Hi, everybody. Jeffrey Evangelos, House District 91. I live in Friendship. And Madam Chair, I sent you and Tom an email this morning regarding Justin Andrus's availability on the bill. He has to leave at 11 today. And he has some good suggestions regarding LD 348. So I just wanted the chairs to know about how long he could be with us.
Great. Well, that's our third bill, so hopefully we'll get to it before 11.
Yeah, that's what I'm
if
worried
not,
about.
We're in trouble.
Right, 10-4.
Okie doke. So Representative Newell, go ahead.
Thank you, Madam Chair. Good morning, everyone. I'm Rena Newell. I am the tribal. I want to be in that tent right
now. Representative Newell, could you reintroduce yourself? I didn't. I think we had some static.
Yes, thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the tribal representative for the Passamaquoddy tribe.
Thank you. Senator Sanborn.
Thank you, Madam Chair. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. Representative Babbage.
Thank you, Madam Chair. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
And Representative Reckett?
Thank you. I'm Lois Reckett. I represent District 31, which is the ocean end of South Portland. And I'm like crazed trying to make my other computer be quiet so that it doesn't interfere with this participation. But I have a hearing in the other committee and I have to bounce back and forth. So I may run into the other room with you guys when I need to talk. So, since I can't figure out how to mute the other one.
Okay, thank you. Thanks for being two places at once for us.
Jeez.
Representative Moriarty?
Thank you, Madam Chair. Hello, everyone. I'm Steve Moriarty saying good morning from a rainy House District 45, which is Cumberland and part of Gray.
Representative Sheehan?
Thanks, Madam Chair, and good morning, everyone. I'm Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. Representative Libby? She may not be available. And Representative Harnett?
Thank you, Madam Chair, and good morning to everyone. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And I'm Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, a little bit of Scarborough. I reside in Cape Elizabeth, and I'll be leading our work sessions this morning. And as a reminder to the public and committee members, the work session is when the committee discusses among itself the bills, and we take votes on the legislation that we previously had public hearings on. There are some folks who are attendees at this meeting who we may bring into the work session to answer particular questions. And to those who are in the attendee space, please don't use the chat function, but just raise your hand and we can, as needed, bring you into the panel. And with that, we will begin our work session on LD 902. This is an act to enact the Uniform Registration of Canadian Money Judgment Acts. And this is a bill that the committee really would like to combine with LD 903 so that we can carry the subject matter of 902 together with 903 over in order to allow some additional work on those complex issues. And so with that in mind, I would entertain an ought not to pass motion on 902. Representative Harnett?
Thank you, Madam Chair. I move ought not to pass on LD 902.
Is there a second? Representative Sheehan has seconded. Is the committee ready for the vote? Looks like we are. And that reminds me, I apologize for my rudeness. I would like to also introduce our analyst, Peggy Reinsch, and our committee clerk, Susan Panett. And with that, Ms. Panett, you can go ahead and call the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 10 members in the affirmative, 0 in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And with that, we'll close the work session on 9:02. And then with 9:03, I would entertain a motion to table. Representative Moriarty has made the motion. Are you seconding it, Representative Harnett?
Yes, I am, Madam Chair.
Representative Moriarty, did you wish to be recognized? We're not able to hear you.
Sometimes the sponsor may be the last one to know, but I didn't realize that these were being carried over.
I apologize. I wanted to let you know that the Uniform Laws Committee had worked on both of these, but there is still quite a bit of technical work to make them conform with the main statutes, and with where the revisor's office is right now on getting all the bills ready for the to complete the session. There's just not the people power to do that technical work right now. And so that's the reason for the carryover, in addition to needing kind of the time to merge 9:02 into 9:03.
Did you speak with Paul Chaikin?
I believe that our analyst has spoken with him.
Yes, I have spoken to Paul Chaikin, who's one of the Uniform Law Commissioners.
Right.
And he understands that there's a certain amount of work that needs to happen. And we just don't have the capacity for that right now.
So he's on board with that, Peggy?
My understanding is he is okay with that, as you know, it's going forward.
Well, he never called me, so I'll take your word for it.
He's actually an attendee right now.
Oh, okay.
And so my question, are you tabling with a vote to carry over later?
Yeah, no, this we can vote to carry over now, actually, because we know that we have to use one of our precious carryovers in this way. Yeah, so let me ask for a corrected motion then. And Representative Moriarty, I also wanted to let you know that the reason that we're combining the two is because our committee, we have 170 bills. And so we have 17 carryovers that we are allowed to use. And we're kind of doling those out as very precious resources. And so if we combine these two, because their subject matter is so closely related,
yes,
it allows us to efficiently use those carryovers.
Yep, I understand.
Okay. And so with that, Representative Moriarty, are you comfortable amending the motion to table and carry over?
Yes, that's fine.
Okay, and Representative Harnett, your second is good for that? Okay. Representative Evangelos?
Thank you, Madam Chair. For a point of clarification, are we on 9:03 now?
Yes, we had a motion to table to not to pass on 9:02.
Right.
And now we're on 9:03.
Just for the record, you said we were on 9:02, and I just wanted to clarify the record.
Oh, I'm sorry. Sometimes I get my numbers mixed up, but I'll be more careful.
No problem. I'm not complaining. Just wanted the public to know which bill we were on. Thanks.
Yep. Thank you. All right. Committee members, are we ready for the vote?
Yeah.
Thank you, Ms. Panett.
My apologies. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier. Representative Thorne.
Yes.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 10 members voting in the affirmative, 0 members in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And with that, we'll close the work session on LD 903 and move on to our third bill. And I know there are a lot of folks in the attendee room, and I would just like to announce the order of bills so that everyone knows where we'll head today. So our next bill is 348, then 483, then 1326, then LD 785, then LD 868, then 861, then LD 747, LD 1096, then LD 887, and our final bill is LD 461. I hope that answers some questions from the folks in the attendee space. And now we'll open our work session on LD 348, an act to give oversight powers to the Maine Commission on Indigent Legal Services. And Peggy, could you please give us kind of a top line bill analysis on this one?
Yes, thank you.
Thank you.
So Title IV, Section 1804 lays out the duties and responsibilities of the Maine Commission on Indigent Legal Services as opposed to the executive director. That's a different section. This bill gives the commission power. I feel like I'm echoing.
That's my fault. It's me that's
It's great. It gives the commission the power to remove an attorney from a roster when the commission determines after notice and hearing that the attorney has violated the law or a standard adopted by the commission. The commission has actually adopted rules already that give the power to the executive director to make those decisions. That power wasn't, and then with an appeal to the commission itself. That power or authority wasn't really exercised until Justin Andrews became the interim director, and he has been able to review any kind of violations of law or standards and has exercised that power now. And I believe he said at the public hearing that there was actually an attorney whose work with the commission he had suspended that has an appeal pending before the commission. That's it. Sorry.
No, I cut you off. I'm sorry. I was multitasking. I wanted to let folks know that I did list the bill order in the chat function as well, so that panelists and attendees can take a look at that. Thank you very much, Peggy. Representative Evangelos, did you wish to speak?
Yes, thank you. Mr. Andrus has contacted me overnight, and in a minute, I'd like you to recognize him to hear his suggestions, and if it's possible that his suggestions can be incorporated through his administrative power. And I'm satisfied with that. Then I'd be prepared to, withdraw the bill if it's not necessary. That's the first thing I wanted to say. The second thing I wanted to say, and I want to draw everybody's attention to page 5 of the bill analysis, about halfway down. And I know Peggy is not responsible for this language, but I've read probably 1,000 bill analyses in my life, and I have never heard a comment like this. This bill is the latest attempt by 1 or 2 commissioners and some others to usurp the authority of the executive director and to exercise control over all decision-making. I mean, that is very close to a slanderous remark. And if somebody's going to be making accusations like that, they ought to, be put on the record as to who they're talking about. Clearly, the opponent of this bill from Macville is accusing publicly in a public forum commissioners of usurping authority. And that was never the intent of this bill. This bill rose out of the malicious prosecutions in Hancock County by a deputy prosecutor who then became a member of our roster. And I raised this case with the former executive director because I didn't think taxpayers should be subsidizing her salary. I went through the whole thing. I'm not going to go through it again. The bar found that she committed 7 bar violations.
Yep. Thank you, Representative Evangelos.
No, this is important. And then
right, but it's already been stated, and I would just
I know, but I have
ask
something
that
else to
we
state that's new, and I'm going to
want to
finish.
hear from Mr. Andrus.
I know, just let me finish. And just yesterday, the second part of my complaint was the subject of a favorable Supreme Court ruling, and I hope Mr. Andrus would.
I'm going to rule you out of order and ask you to let us hear from
I'm
Mr.
not out of
Andrus
order.
so that we can move on.
I object to the fact that you just tried to rule me out of order. I have a right to speak about my bill. Every other sponsor has been recognized. And, I plan on being able to speak like everyone else. Thank you.
Mr. Andrus, can you activate your camera and your video? Welcome back to the Committee on the Judiciary. And I understand that there are some administrative changes that you have agreed to make that will obviate the need for this legislation. Can you review those with us, please?
So if I may please just frame very briefly. First, after I testified, as you may recall, I went running right out to go to a commission meeting where I raised this issue with the commission, but because it was new to them at that time, they didn't vote on it. I got good feedback, but today I'm here in my capacity as executive director. The commission hasn't expressed this is getting to be old hat. Every time I appear in front of you, I say that, but I want to make sure that's clear. There are existing rules, and we can review them to the extent that's helpful. The rules are useful, but need to be tidied up. I haven't yet implemented a proposed administrative change, but I have a proposed administrative change in our rules or for our rules. And I will leave, of course, to the committee whether that needs to be codified in a statute or not. So as I understand Representative Evangelos's concern, as far as the procedural aspect of it, I understand his substantive concerns as well, but they're not for me here. The issue is there is the potential for an executive director to dismiss a complaint without review of that decision. And so the bill as written would vest the review power directly in the commission, which would be problematic from an appellate perspective. But my recommendation to the commission is that we adopt something similar to what the Board of Overseers does. So an assistant bar counsel or bar counsel who reviews a complaint and determines that doesn't state a complaint or for some other reason shouldn't be pursued. The complainant is advised of that, and the complainant has an opportunity to request review by a public non-attorney member of the grievance commission. Here we don't have quite that, but we do have non-voting members of the commission. And so my recommendation to the commission and my recommendation as executive director to you is that for those complaints that are provoked by a person as opposed to sua sponte on my part, if the outcome is no action, that there be a standard letter that says you have 21 days or whatever it is to request review by non-voting member. That provides a little bit of oversight on the executive director's decision, but also preserves all of the voting members of the commission to serve as the appellate body. And so if that non-voting member, so the way it works at the Board of Overseers is that if the public member says, nope, it was dismissed in error, then bar counsel brings it forward to the grievance commission to decide whether or not to pursue. And I would say the same thing would be here. If the public member, non-voting member rather, of the commission said, no, there's really a problem there, then that issue of what to do would go to the commission. We'd lose in those relatively few instances, I think, but we would lose the appellate review in that instance because people would be conflicted, but there's still an 80C appeal above that. So that was a lot of spiel. I see all your eyes glaze over. I'm sorry. But that's what I would do that I think vindicates Representative Evangelos's concern while leaving the administrability of the agency, with the executive director and preserving that appellate body.
Thank you. That I can see where that would address the concerns. We've got some questions. Representative Moriarty.
Thank you, Madam Chair. I know that Representative Evangelos's intention was to put this authority to terminate into statute as opposed to commission rule. And I'm just wondering whether, instead of empowering the commission to terminate, we can, under the statute, empower the director to terminate and include language regarding an appeal to the commission from the director's decision. It's either that, or I would ask my colleague, Representative Evangelos, whether he is comfortable with letting the commission take care of this in-house.
Could you go ahead, Representative Evangelos?
I'm comfortable either way because the process that Director Andrus just outlined dealt with my concerns. I don't want to create a duplicative, confusing process. My main concerns were around a due process and the allowance for parties to be heard. And even though I brought issues forward about a specific former DA and now attorney, I also wanted to make sure that person had due process, protecting the rights of everyone. I think that the objectives behind the bill have been satisfied. That notwithstanding, remember Mr. Hayden said that, as far as he was concerned, the process has never been used. But I just want to make sure that all of the parties and those roster attorneys, get, their say-so in front of the commission and a right to appeal, and that there be a process of due process. And I'm satisfied with what Mr. Andrus has said. Representative Moriarty, if you want to get something codified in statute, that's okay, but I'm not sure it's necessary after what he's spoken about today.
Other committee members' comments? Go ahead, Representative Babbage.
Thank you, Madam Chair. If I may just ask for a clarification, I'm familiar with the rules under qualifications, I believe. What is this entitled here? Excuse me. Standards for qualification, right? That the executive director does have the power to remove. In the parts that deal with the commission's powers, is the commission already established either in statute or in rule as the appellate body to the executive director's decision making?
Yes. I'm sorry, Madam Chair. May I?
No, go ahead, Mr. Andrus.
Thank you. The answer is yes. And so the statute delineates certain decisions for which the commission acts as the appellate body, but not all decisions. Not everything somebody might be aggrieved by flows through the commission, or the commission as the appellate body. I think that just
so what's being asked here is not an appeal on a penalty, but an appeal by a complainant.
So as I understand it from the bill and from listening to Representative Evangelos and speaking to him a little bit, there were at least two things that he was looking to make sure were added, both of which I endorse. in my capacity as executive director. So the first is to make sure that anyone who is aggrieved by my decision to de-roster them has due process to ensure that my role can't be abused. That to me seems both appropriate and necessary. The other thing is to make sure that if essentially that there's a check on the executive director to ensure that a matter which should not have been dismissed is not dismissed for an improper purpose of some kind. And I'm not ascribing improper purpose to my predecessor in the instance that Representative Evangelist talks about. But that's really, and that's perfectly appropriate, necessary. That's the same reason that opportunity exists at the Board of Overseers. So two things. What I really have is contract authority. And I think I said this when I testified, but really what I'm deciding, it's not disciplinary and it's not a civil action, it's not a criminal action. It comes down to, will the agency contract with the person again? And that is something on which due process is generally due, frankly, once somebody has a contract with the state. And then the other part of it is, I think I had said last time there were about 15 instances where I'd open investigations. I think I'm up to about 18 now. Most of those are sua sponte. Most of those, something came to my attention that made me want to reach out to a lawyer and say, what's going on? And so those won't invoke this secondary process because I'm the complainant. But I do get letters from lawyers. I've got an order from a judge specifically referred to me for review. Those kinds of things happen. And those people should get a report back and the opportunity to say, somebody look over his shoulder and make sure he's right.
Thank you for that. Thank you, Madam Chair.
Yeah. And so just to clarify, so what you're proposing, Mr. Andrus, is to change the rules to incorporate that same kind of report back and opportunity to bring concerns to a non-voting member of the commission when there's a so-called third party who brings a complaint against a panel member.
Yes, and just to make sure I stay in my lane, what I'm proposing is to recommend that to the commission. And in fact, I have started discussing that with the commission at the meeting immediately following the testimony. But ultimately, I don't have the authority to just do that, or I would. And I anticipate that they're likely to follow that recommendation, but I can't make the promise quite yet.
Thank you very much for that clarification. Representative Evangelos?
Thank you, Madam Chair. I have a quick question for Justin. Mr. Andrus, so on a hypothetical, if you move to de-roster an attorney and they appeal, is the de-rostering put on hold until the appeal is heard?
The answer is not categorically. And I think I would exercise my discretion based on a schema of sort of hierarchy of immediacy of the problem. I think it would depend to a large extent why I chosen to take them off the list. I would look at the extent to which they posed a threat or a risk to either a specific client or the client population. I might look at whether or not I can perform my Sixth Amendment function with them off the list if it's not something that is exigent. And so I think those would all factor in. And I would be responsible for preparing a decision that laid out that thinking and said, this is why I either have or have not eliminated this person from the roster in the interval. I have a hard time imagining a performance or misconduct-based reason that I wouldn't suggest somebody come off the roster. But also, and I think this is important, in our rules, I have the ability to impose conditions. And so I can essentially make continuing practice with us probationary. I haven't had an opportunity to do that yet. But I was a fan of deferred dispositions as a criminal attorney. I was a fan of the Alternatives to Discipline program when I was at the Board of Overseers. And I think there's an opportunity to help safeguard without eliminating in a lot of, where the issue is a discrete performance issue.
Just in response to that, just keeping in mind the presumption of innocence regarding any party, I would hope that you mentioned staying in our lanes, but if somebody did contest your decision and ask for a hearing in front of the commission, I would hope the presumption of innocence would allow them to continue to practice, under conditions that you imposed, rather than have a suspension of the privilege to practice before they get a hearing. So would you please keep that in mind for me?
I will keep that in mind. My first goal operating this agency is to provide acceptable and appropriate counsel to the people who need it. And I don't do that by removing somebody who doesn't need to be removed. I keep that in mind in every decision I make in terms of trying to make sure that I maintain a roster of really great attorneys who can do the work. So I will always keep that in mind.
Thank you.
Thank you, Mr. Andrus. And committee members, I feel like we have thoroughly vetted the proposal, and would recognize Representative Harnett.
Very quickly, I want to move along too, Madam Chair. I understand why the bill was introduced. I understand what Mr. Andrus has explained, and I appreciate it, but he also indicated he cannot predict that the rules will be adopted by the commission or not. All I would ask for is a report back to the committee when that has happened, so that if need be, a bill like this could be brought up next year. That's all. I'm just asking for a report back. Thank you.
Will do.
Thank you very much. And is the committee ready for a vote? No, Representative Evangelos, go ahead.
Representative Harnett, should we just table the bill until we see the outcome, and then we can, when we see what Mr. Andrus brings back to the committee, I can make a motion not to pass at that point. Would you feel more comfortable with that rather than bring it up in another legislative session?
I think I'd prefer a motion ought not to pass, because I'm not sure how long the rulemaking process is going to take under the APA, under the Administrative Procedures Act.
Okay. Well, he hit the high points of what I was concerned about. So I'm not going to make the motion to kill my bill, but I am satisfied with the responses I've received from the director today. So thank you for that.
Then I would prepare it, if it's okay, Madam Chair, to make a motion ought not to pass on LD 348.
Thank you. Is there a second? Seconded by Representative Babbage. And Representative Evangelos and Mr. Andrus, thank you so much for bringing this idea forward and finding a really appropriate solution to it. And with that, is there any more discussion on the motion? With that, Ms. Panett, if you're ready, we are ready for the vote.
Madam Chair, I see 2 hands raised. I don't know if they just need to bring them down.
I think they're residual.
Perfect. Thank you so much. Okay to go. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentee. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent. That is the vote of the committee.
Thank you, Ms. Panett. And so the motion carries, and therefore we will close our work session on LD 348 and open our work session on LD 483. And this is an act to clarify funding for civil legal services. And Peggy, if you could please give us the bill analysis.
Yes, thanks. So this is an emergency bill, so it would take a 2/3 vote. It does a couple of things. One, it amends the statute that provides how the Civil Legal Services Fund is funded. There are surcharges on different filing fees, as well as some civil violations. This amends the paragraph C, which is about surcharges and it was amended last year, and it didn't actually capture everything that was intended to be captured. Actually, I think it was amended in 2019, not in 2020. And so this amends it to change the surcharge, keeps the surcharge of $127, but it applies the surcharge to commencement of each debt collection action. It used to be small claims. So debt collection action or money judgment disclosure action when it's brought by a debt collector as defined in Title 32. And it goes on to say that that surcharge is not a recoverable cost under the civil litigation statutes. That's what Section 1 does. Section 2 clarifies that the Judicial Department can refer cases to the Court Alternative Dispute Resolution Service, their mediation service for mediation, and the fees can be deposited in that dedicated account for the court mediation service.
Thank you. And then there was a suggested amendment to the bill.
Right.
And I think it was just striking out the words subsection 6 in section 1.
Right. And that was, I think that was recommended by the judicial branch.
Okay.
And some folks who oppose the bill suggested that the rather than applying the surcharge in narrow cases, you could create a surcharge that's broader based and wouldn't need to be as high a fee, but that really hasn't been fleshed out. I tried to include all the statute about the Maine Civil Legal Services Fund, so you can see all of that. So it does include a $10 surcharge on each civil fine, penalty, or forfeiture. But that's not being changed by the bill.
Thank you very much. Representative Senator Sanborn.
Thank you, Senator Carney. I wasn't able to be at this public hearing, but I just wanted to provide the committee with a little bit of background on this because it was my bill that originally back in the 128th legislature added additional regulation and protection for consumers who are targeted by debt buyers, which is a practice where folks buy up whole spreadsheets full of debt at pennies on the dollar and then attempt to use our court system to get default judgments against those debtors and then to go after them for the collection of debt, but without much actual verification or evidence that they actually owe the debt. And in many cases, they didn't. But once you convert it to a default judgment, it's very hard to get rid of. So there's now a number of safeguards and protections for folks who are targeted by debt buyers. And in order for those protections to be operational, we had to ensure that those debt collection actions didn't happen in small claims court, but instead happened in a place where evidentiary rules were applicable. And so we made that change as a second step last session last legislature in the 129th. And then it created this additional wrinkle where the $127 surcharge, which had already been applying to debt collection actions because they were happening in small claims court, now no longer was being collected. And then that created an issue with regard to funding of civil legal services. So I just wanted to sort of outline the timeline here. It's really, really critical that we restore this fee. And I think by volume, the fee was very much previously imposed on these same actors in the same amount. And all we've done is sort of move the venue. And so that's why it is extremely appropriate for us to just simply restore this fee to this group and not to monkey around with creating a more broad-based fee or a different level of fee or anything like that. This is absolutely, just sort of within sort of this strange moving pieces of how this statute has evolved to protect Maine consumers from these debt collector or debt buyer actions. So I really encourage the committee to help us close the loop on this. Most of the action on this has been over in my other committee where we regulate financial services and debt collection and debt buying activities. And so now we're over here just fixing this last little piece of the three-part puzzle. So I hope you'll support the bill.
Senator Sanborn, can I just ask a clarifying question? So this fee is not imposed on, say, a company in Maine that delivered oil to a homeowner and then tries to collect, the company itself tries to collect the cost of the oil. It would only apply to companies that go out and buy debts that are owed from other businesses or are in the business of collecting debts, not their business's own debt, but the debts of other businesses, that they're kind of consolidating all of these debts that are owed and bringing them to our court system.
That's right. You have to be a debt collector within the meaning or within as that term is defined in Title 32 in order for the surcharge to be imposed here. And so that's right. It would not apply if the oil company wanted to try and collect on its own debts. But if it sells them off or assigns them to a debt collector, then that's when this statute and this fee would come into play, as well as the requirement not to bring the claim in small claims court.
Thank you very much. Representative Moriarty.
Thank you, Madam Chair. A question for Senator Sanborn. You mentioned that it's important to restore the surcharge, and yet in the statute, which is appended to Peggy's memo, there clearly is an existing $127 surcharge for the filing of a small claims proceeding anyway. So what is it that has to be restored that isn't already in the statute?
Yeah, so these claims used to be brought in small claims court, and the statute, the surcharge only applies in small claims court, but these claims can no longer be brought in small claims court. And so now the surcharge never applies because these claims are barred from small claims court.
So you mean a claim brought by a debt collector for $300 can't be brought in small claims court?
Correct.
Where is it to be brought? Civil action in district court?
Yes. Otherwise, the evidentiary rules don't apply, and therefore the consumer protections that we put in place can't be imposed by the judge.
Doesn't that impose a real burden upon the debtor to defend an actual civil action as opposed to a small claims action?
So we've already, that's not the policy question that's before us, and that's been resolved last year. So that's already the statute, and we had a very full hearing and discussion about that issue. And on balance, because of the very clear evidentiary standards that we put in place to protect debtors and the need to actually make those standards enforceable against debt collectors, on balance, we have already made the policy decision as a legislature that it makes sense to move the venue out of small claims court because what was happening was that debt collectors were going to small claims court and being able to obtain basically either default judgments or just basically automatic judgments against these debtors because evidentiary rules do not apply in small claims court. And so we could not, so the consumer protections that we have put in place are evidentiary in nature. They require the debt buyer to provide evidence of a number of different aspects of the debt, and they put a large hurdle in front of the debt collector before they're able to obtain a default judgment. And that's really that's what generally is occurring. There's a huge volume of these claims. The debtor generally doesn't even show up, and they are converted into a judicial ruling that the debt is owed. And once that happens, it's very much impossible for these debtors to defend against the default judgment. That's the problem. So that's not the issue before us today, Representative Moriarty, and I want to stay really, really focused on the very narrow bill before us. The policy determination of what venue these claims should be brought in is settled. It's not before us today. All that's before us is the fact that because this surcharge only applies in one venue and we've moved all these cases out of that venue, the surcharge has gone away. And we're talking about thousands of cases, very small, but many of them. So I hope you'll just, address the issue in front of us today, which is the surcharge issue, and making sure it continues to apply in the same way and in the same amount to these debt collection actions as it did prior to the change of venue.
Madam Chair, may I try one more question?
Yes.
Senator Sanborn, it looks as though there are multiple surcharges, one for filing and then one for a collection proceeding, assuming that you've either won your case or there's been a default. Am I reading this correctly?
I would just note, I don't think those other surcharges are the subject of this bill.
That's right.
This is really, Representative Moriarty, this is really about, there were a whole bunch of cases that were being bought by businesses that are exclusively focused on debt collection. Right. And they had a fee. They were told to bring their cases in district court instead of small claims court, and the fee never caught up with them. And this is just trying to catch the fee up to the shift in the court that they're filed in. Does that help answer the question?
The question, I guess, is how many times is the surcharge imposed? Whether it's brought in district court or elsewhere.
Go ahead, Senator Sanborn.
Right now, it can't be imposed at all. But previous to the change in venue that happened in the 129th legislature, it was imposed very often anytime a debt collection action was brought in small claims court, and that's where many of them, or if not most of them, were brought previously. And the $127 was an important source of funding for civil legal services in Maine.
Okay, I don't want to get beyond the scope of the bill, but I don't think I'm seeing this clearly. And I think Mr. Greenberg, who's the witness, made a point that those who are collecting debts pay the surcharge more than once. And I'm not hearing anybody say, no, that's not true.
It's once per filing. It's not. It's at the time of filing, I believe. At the commencement of the action.
Well, I don't want to argue, but I think there are two kinds of actions. One is the action on the indebtedness claim, and then one, assuming the collector prevails, there would then be a disclosure hearing. And so I'm wondering if the same surcharge is imposed both upon filing of the claim for the debt and upon the filing of a request for disclosure proceeding.
I think if there were two separate actions that were commenced, there would be two separate fees. Is that either Senator Sanborn or Peggy? I feel like it would be good to turn to one of you for confirmation.
Yes, that's right. But it's also the case that that was the case before. So that's the status quo ante, is that if you filed a claim for debt collection or a claim for disclosure action, which used to both be able to be brought in small claims court, then you would pay the fee. So again, it's not a change, it's just a change of venue, and we need the statute to be updated to account for the change in venue that happened in a different part of the statute.
Okay, I'll pause. Thank you.
Thanks, Representative Moriarty and Senator Sanborn. Representative Harnett?
Thank you, Madam Chair. I would like to make a motion and speak very briefly to the motion.
Go ahead.
I would like to move ought to pass as amended on LD 483. And I do that for the reasons stated quite clearly by Senator Sanborn. Our legislators made the policy decisions about the need for these fees and the use of those fees to fund various legal services programs throughout the state of Maine. All this bill is doing is reflecting the fact that those cases are no longer brought in small claims court, which was the limitation placed in the prior statute, and simply reflects that those cases are now being brought in other courts. It changes nothing other than that. And I would urge my colleagues to support the motion. Thank you.
Representative Babbage, is your hand up to second the motion?
Wait a minute. Oh, yes, I'm on. Yes, I will second the motion, but I do have a question for discussion.
Okay, go ahead.
Thank you. I appreciate Senator Sanborn's excellent summary history and her actions in the past. And I appreciate Representative Moriarty's question. So my question, maybe just from being regarding this process, but it is important that I intend to vote for the motion. I think this is good, but it is important that we understand the consequences of what we do. So I would like a definition of a disclosure action and ask if that is, if the two-step process is, common. Is a two filing charge the norm, or so definition of a disclosure action and an answer to that, if I could. Thanks.
Okay, so we're kind of beyond the public hearing portion of this bill, and we're in a work session, and
I'm asking for understanding the consequences of my vote, Madam Chair.
Okay, all right, Senator Sanborn, can you address that one, please?
Sure. A disclosure action is an action where you go back to the judge and ask that an order be issued for the debtor who already has a judgment against them to have to disclose whether they have assets to satisfy the judgment so that the judgment can be collected upon. It's a different cause of action than a debt collection action. And my understanding, although I'm not a civil litigator anymore, is that it has to be brought in a separate at a separate stage, because you have to have a judgment in order to file a disclosure action.
And it is a normal part of the process.
Peggy can correct me if I'm wrong, but I think that's right.
Right. I think that was the intention of the language that is current law that says money judgment. That's really talking about a collection of a money judgment, and the way you collect a money judgment is, I mean, you bring the debtor into court to say, we have a judgment, time to pay, how are you going to do this? And you can do a disclosure action, which makes them show the information about their assets, what they can pay, and you can actually develop some kind of a payment plan. It's a court sanctioned payment plan. So I think the language, it looks like it's something new, but it's really a little more descriptive of what was intended, is my understanding of it. It used to just say small claims or money judgment when the action is brought by a debt collector. And so what this is clarifying is that it's a debt collection action because it's no longer in small claims, or a money judgment disclosure action. So it's how you actually get your money out of that judgment.
Thank you. Thank you. Appreciate it.
And I would just add, and I understand and appreciate your clarifying question, Representative Babbage. I would just add that you don't always have a disclosure action. Sometimes a judgment is obtained and paid. So the disclosure action is just a second step that's sometimes necessary. Committee members, are we ready for the vote? The motion is ought to pass as amended, with the amendment simply being striking the word subsection 6. That was what was inadvertently left in the bill language. And Representative Babbage, is your hand up anew? All right, thanks. Ms. Panett, go ahead.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt. Representative Galgay-Reckitt votes yes. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And that draws our work session on LD 483 to a close. And the next matter that we are going to take up is LD 1326, an act to provide funding for the Maine Civil Legal Services Fund. And Peggy, if you can give us excuse me. Thank you very much, Supi. I forgot the minority report, please, for those who voted against the motion.
Ought not to pass for me.
Yes.
Thank you. Thanks for catching that, Supi. All right, and now we'll move on to LD 1326. And Peggy, if you could give us the analysis.
Sure. So this is somewhat related to 483, and it is actually not amending the statute, but straight appropriation to the fund, the Civil Legal Services Fund. And it would be $8.3 million in the first year and $14 million in the second year. And if you remember, this is tied to the 10-year plan to try to get the number of civil legal services attorneys in the state up to the national legal index of 10 per 10,000 in the 10,000 population in the state. And because of the pandemic and because of the change in the statute last year, kind of lost ground in how much funds were going to the Civil Legal Services Fund. And so that is it's kind of catch up money. I think it's really intended to be adding $7 million each year is the plan.
Thank you. Committee members, are there questions for Peggy? Not seeing any. The bill sponsor is in the attendee space. I don't know if anybody has questions for the bill sponsor. Go ahead, Representative Harnett.
I'm sorry, I'm jumping the gun. I do not have questions for the bill sponsor. I'm prepared to make a motion at the appropriate time.
I don't see any other hands raised, so go ahead and make your motion.
Thank you, Madam Chair. I would like to make a motion ought to pass on LD 1326 and speak to the motion very briefly.
Go ahead.
Thank you, Madam Chair. And just earlier this week, we heard during Access to Justice Day about the difficulties faced by low-income Mainers in securing legal services in times of need. We are well below the index that is recommended on a nationwide basis in the terms of the numbers of attorneys available to provide these services to our poorest Mainers who are struggling on so many levels. And for those reasons and for the reasons we heard from both Acting Chief Justice Mead and all of the service providers earlier this week, I urge you to support my ought to pass motion. Thank you, Madam Chair.
Thank you, Representative Harnett. Is there a second? Seconded by Representative Sheehan. Any additional discussion on the motion? Not seeing any hands raised. Ms. Panett, thank you very much.
Thank you.
We have a hand raised. Go ahead, Representative Libby.
Thank you. I will be voting not to pass. This is an item that should have been included in the biennial budget, which should have been an ongoing conversation. And I have to disagree with the bill sponsor. We are to discuss money as well as policy. Fiscal notes were created in 1966 to ensure that legislators did not just pass policy bills with no consideration to the fiscal impact. It is our responsibility to understand the fiscal impact of our decisions and to not pass that off to the Appropriations Committee. So I will be ought not to pass.
Thank you, Representative Libby. Committee members, any other discussion on the motion before we move to a vote? Okay, I'm not seeing any hands raised. Ms. Panett, thank you so much for joining us, and you can proceed with the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Where
am I? Wait a minute. Just a second. Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 9 members voting in the affirmative, 2 in the negative, and 3 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And for those who voted against the motion, could you please let us know what your report is?
Ought not to pass.
Thank you very much. And with that, we'll close the work session on LD 1326 and move on to our next. Next on our list is LD 785, an act to change the standard for assessing risk of serious harm. And Peggy, if you could please give us the bill analysis. Thank you.
So the bill amends part of the involuntary commitment laws. It amends the definition of likelihood of serious harm, which consists of 4 paragraphs. This amends 1 paragraph, and it includes, in view of the person's treatment history, current behavior, and inability to make an informed decision, a reasonable likelihood that the person's mental health will deteriorate and that the person will in the foreseeable future pose a likelihood of serious harm as defined in paragraphs A, B, and C. So currently, that definition of likelihood of serious harm applies only to the progressive treatment program, where somebody is already part of the program. There's already a court order, and because there's a history, they can be in the community, and the history is taken into account. So they can be brought back into the hospital if their condition deteriorates, and they've already agreed to that that process. If they're not taking medication, which is what makes them eligible to be in the community rather than in a secure facility. So it looks like it's a really small change, but right now that kind of forward looking, we have this information and we're going to apply it going forward, is only used in the progressive treatment program. And right now, the likelihood of serious harm that applies to people who are not in the progressive treatment program, it's A, B, or C. It puts them in the position to be considered for involuntary commitment. And I think I included, I know you have that in the statute, and I can share that if you need to see that on screen, because I guess I didn't put it in my bill analysis. But A is a substantial risk of physical harm to the person as manifested by recent threats of or attempts at suicide or serious self-inflicted harm. So a substantial risk right now. B is a substantial risk of physical harm to other persons. And C is a reasonable certainty that the person will suffer severe physical or mental harm as manifested by recent behavior demonstrating an inability to avoid risk or to protect the person adequately from impairment or injury. So if you remember the testimony at the hearing, that was the other piece, which was the inability to avoid risk. They might have risk of physical harm or self-harm, but if they're able to avoid that risk, then they don't necessarily fall into this definition of likelihood of serious harm. And that's one of the issues there you need to think about in going forward, changing the definition of likelihood of serious harm. You have a whole lot of people that testified, and the Attorney General's office offered to provide assistance, and Molly Moynihan is an Assistant Attorney General, and she is in the attendee room, and she has offered to kind of give you an overview of the whole involuntary commitment process, if that would be helpful. And she can kind of answer more of the process questions that are beyond my ability right now.
Thank you very much, Peggy. And I do think it would be helpful to bring Ms. Moynihan onto the panel so that she can provide us a bit more information about the process. This was a very intense bill hearing, and also the issues are very serious. And so I think taking some more time to focus on the process would be appropriate. And Ms. Moynihan, thank you for joining the Judiciary Committee this morning and for sharing with us some additional information.
Yes, good morning, Senator Carney, Representative Harnett, and the honorable members of the Joint Standing Committee on the Judiciary. My name is Molly Moynihan. I'm an Assistant Attorney General. I've been with our office since 2014, and my primary focus in the office is doing work related to mental health. I'm quite familiar with these statutes. I appear regularly in district court on these hearings. I also provide trainings on Title 34B to our state agency clients at the 2 psychiatric hospitals. And I also participate in training for law enforcement under the Crisis Intervention Training Program. I've actually listened to all the public hearing and am familiar with some of the issues that were raised and questions that were raised, and I'm happy to provide an oversight of the statute or overview of the statute and kind of lay out some of these concerns in a little more detail. I think one thing that would be important for the committee to note is that even though this appears to be a simple change, just crossing out a few words, I think there's significant consequences in the statute. For one, this definition of likelihood of serious harm appears multiple times. So it's not as simple as getting a person right into a psychiatric hospital. It's a repeat definition throughout the process. So if I may, I can go over kind of how the statute works and what the processes are, if that would be helpful to the committee.
Yes, that would be very helpful. Go ahead, and thank you.
Thank you. So I think where I like to start is looking at the definitions, and those are in section 3801. And there's a number of very important definitions in here, and they all have significance in the statute. And of course, the one before the committee today is what is the definition of likelihood of serious harm? And Ms. Wrench did a nice job explaining kind of the 4 paragraphs right now. I did want to just briefly note, and I know analysts can...
Ms. Moynihan, I'm sorry to interrupt you, but I'm wondering if committee members would like us to screen share the statutes as we're looking at them. I'm seeing some nodding heads.
I can do that if Ms. Moynihan isn't ready for that.
That's fine. And just Ms. Wrench, I think the statutes I'll be focusing on are sections 3801, that's the definitions, section 3863, that's our emergency blue paper process for commitment. Section 3862, I'll touch upon briefly, that's protective custody. And section 3864, that's the district court process that happens following an emergency commitment. And I can go through these as briefly as possible. I know that the committee is, I want to be aware of the time. And just to let everybody know, I probably look at this statute multiple times a week and look at it frequently. There's so much information in there and so much detail in there that's very, carefully designed. So I just want to impress upon the committee that these changes, making one change has an impact to multiple other sections. So the definitions are very important. And of course, section 38014A is what's before the committee today. And there's the 4 paragraphs, which have already been discussed. I did have an opportunity to look online at the digital library and noticed that the definition itself with these first 3 paragraphs, A, B, and C, have been in existence since at least 1983 in one format or another. And I like to think of the definitions as, the first paragraph is a substantial risk of harm to self. Paragraph B, a substantial risk of harm to others, which can include placing others in reasonable fear of serious physical harm. And C is somewhat broader. It's a reasonable certainty that the person will suffer severe physical or mental harm. And that, of course, all three of these paragraphs are tied to recent conduct or behavior. And I think part of what I heard at the public hearing may be a focus on dangerousness and imminent risk to self or others. And sometimes it's overlooked that paragraph C is also a mechanism that can satisfy criteria to bring someone into a psychiatric hospital. Paragraph D was added, I believe, in 2005, and that was in conjunction with the introduction of the progressive treatment program. And that paragraph has never, and as far as I know, applied for a person's admission to a psychiatric hospital. It's only applied for admission to the progressive treatment program, which is the outpatient court order. Other definitions here that are important are medical practitioner, psychiatric hospital. There's a definition of mentally ill person. And I would encourage you, if you had the time, to think about all these definitions and how they're interwoven into the statute. I'm going to jump ahead to section 3863.
Ms. Moynihan, I just want to ask you to pause there. And I had a question for you, and maybe if we can pause periodically so that committee members who have questions can ask.
Absolutely.
Thank you very much. So you had just said, I believe you said that the section paragraph D was only added when the progressive treatment program was included in the statute. Is that right?
That is my understanding based on my review of the legislative history.
And that the progressive treatment program, I think you referred to it as an outpatient court order. Can you tell us a little bit more about what that means, please?
Sure. So the progressive treatment program is outlined in section 3873A, and I apologize, Ms. Reinsch, I didn't mention that one earlier, but it's a real important one, and it is relevant to the discussion today. That is a program that was started, I believe, as a pilot project effective in 2006. It started just, I believe, in Bangor at Dorothea Dix Psychiatric Hospital, and it required on an outpatient basis somebody to be followed by an ACT team, which is a high level of services in the community. And there would be conditions requiring the participation in the plan. A court would order it. There'd be a hearing and so forth. That program has expanded over the years. It's no longer limited to just Dorothea Dix or even just the state hospitals. It's available to any hospitals. And I believe the last iteration of the statute may have been enacted in 2012, although I haven't gone back and verified that. But essentially, and I'll look at the language itself, you can see in paragraph 1 that a superintendent or a chief administrative officer of a psychiatric hospital, and psychiatric hospital, of course, is defined in our statute, the commissioner of DHHS, the director of an ACT team, a medical practitioner, law enforcement officer, and so forth. So there's a broad category of persons who can apply for an individual's admission. And then there's the criteria listed in paragraphs A through G. This program is designed for people with severe and persistent mental illness, and that is defined in statute. And then there's that paragraph B, patient poses a likelihood of serious harm. So that's another place in the statute where we're seeing that definition again. And from my experience, I saw in the bill analysis that there was a question about how many PTPs are in existence right now. I did confirm with the 2 state hospitals this morning, and I believe there's approximately 29 that were initiated by Riverview and 22 that were initiated by Dorothea Dix. I have heard, I did hear the public hearing that there may be some concern that this is not available to other hospitals. I do know that Acadia, Northern Lights Acadia Hospital does with some regularity also petition the court for a patient's admission to the progressive treatment program. Other hospitals do it. It's just less frequent than the 2 state hospitals. And just to, and I again, I'm cognizant of the committee's time, but just to give you a little more information on the PTP, it requires an individualized plan. And no longer does that plan have to include services or ACT services. For example, the plan may be as, you know, on one end of the spectrum requiring that the individual comply with medication management, and there may not be any other services. The person may be living independently in his or her own apartment or home, and able to function, and then the only requirement is to comply with medication. On the other end of the spectrum, you might have a plan that's more developed in requiring a higher level of services, perhaps a group home residential component, or case management or ACT services. So it can really vary. It's really individualized, but there are some core requirements, including that the person is suffering from severe and persistent mental illness, and generally that's certain diagnoses, and that the illness has existed or is expected to exist for at least a year. So it's generally for the subset of the population who is, you know, more frequently in hospitals or more frequently entangled with the criminal justice system. Does that answer your question?
Yeah, thank you. Thank you. That was a great summary. And I was just wanting to get at the contrast between A, B, and C, which are inpatient, versus D, which is the PTP, which is outpatient.
Yes, and I might just add too, in the court hearings for a PTP application, we're focused on these various elements, including that the patient is meeting a likelihood of serious harm. But in most of these cases, that looks like somebody, if they're discharging from a hospital, it looks like somebody who has been at the hospital, has stabilized, is no longer in an acute need for hospitalization, has in many instances developed some insight into the need for treatment. So it's individuals who are at a different point in their level of care needs than somebody who is going to be entering a psychiatric hospital in the first instance.
Thank you.
You're welcome. Does anybody else have any questions about the definition section of the statute?
Committee members, please raise your electronic hand, because with screen share, I can only see if your electronic rather than your real hand is up if you have questions. And I'm not seeing any, so you can proceed.
Thank you. So I'll jump back to hospitalization, excuse me. And kind of to put everything in context, and I know this came up quite frequently at the public hearing, is that there's these overarching constitutional issues. And that's always important in thinking about how the statute has been designed and the protections that are in place given the significant liberty interests at stake. And I was struck, most recently our state Supreme Judicial Law Court had issued a decision called AS versus Lincoln Health, and the citation is in the Attorney General's letter. But the court noted there that this emergency hospitalization statute is the only statute that provides a hospital with any authority to hold a person who may be dangerous as a result of mental illness, and one of a very limited number of statutes that provides a civil authority for a person or entity to hold another person against his wishes. So with that, there's significant protections already built into this statute. And starting with emergency psychiatric hospitalization, this is the procedure in section 3863 that is commonly referred to the blue paper. And you're not going to see the words blue paper or white paper or green paper in the statute. So it's good to always tie it back to the actual legal language. So there's several components to a blue paper application. And there's the application itself, the certifying examination, and the endorsement by a judicial officer, which is in section 3. To go over the application very briefly, anybody really can, in that section 1, anybody can apply for someone's admission. It doesn't have to be an expert. It doesn't have to be a medical practitioner. It can be anyone, essentially. who has a belief that the person is mentally ill, and here's your definition, because of that illness presents a likelihood of serious harm. So that's all that's required in the first section. Section 2 is where you get the expert opinion. You have a medical practitioner who is examining the person on that day of when that section of the blue paper needs to be completed. And I noticed in the bill summary that this changing the definition would change what a medical practitioner could look at in terms of making the recommendation of whether psychiatric hospitalization is needed. I would point out paragraph B that already the medical practitioner can look at not only what that practitioner is observing in that moment, they can also consider history and information from other sources, consider reliable. And that would include family, which is delineated in the statute, but it also would include perhaps the crisis worker or others, treatment providers in the community. So that practitioner right now is not limited necessarily as to what that practitioner can consider in making this opinion. So I just wanted to note that history can be included, things like that. One thing that this certifying examination question that comes up is, where does this occur? And you may have heard in the public hearing that often this is occurring in an emergency department. Our statutes don't require it to occur in an emergency department, but most often that is the case. And so then the question is, how does that person get from the community to the emergency department for an evaluation? And that can vary. Sometimes an individual will recognize that they need treatment and that they need some help, and they will present themselves to the emergency department. Other times, a family member may be able to bring them in. And then another option is when law enforcement takes the person into protective custody. And that is in section 3862. And this is just regular 38, so the original 3862, not the new law. So I think this may be where there's some discomfort and concern on the part of community providers and family members and others who are looking to get help for somebody who is experiencing a crisis in the community, is how do we get them to the hospital? And there's the section in 3862 for what a law enforcement officer may do. And the standard here is a little bit different. A law enforcement officer must have probable cause to believe that the person's mentally ill, and due to that condition presents a threat of imminent and substantial physical harm. So this standard is a little bit different. I think it's in recognition of other liberty interests at stake to take someone, put them into a police vehicle. It can involve restraints, even though the statute requires the least restrictive transport be utilized. It could be putting someone in handcuffs. It could be pretty restrictive means to take someone into protective custody. So there's a slightly different standard, imminent and substantial physical harm. I know that law enforcement does their best to try to de-escalate situations, see if the person will come voluntarily without having to employ this statute. But that may be where some frustration exists in the statute by persons who are interested in the well-being of a loved one or someone under their care. I also want to point out that law enforcement under paragraph 1A may take the person into protective custody. So there is discretion on 1A, yep, right there. There's discretion on the part of that law enforcement officer who may be called to address a situation where there's a crisis occurring. And they may be reluctant for one reason or another to take the person into protective custody. So that may be another, what some may perceive as a barrier to someone getting to a hospital. And I know there's been some testimony about advanced healthcare directives. If this section also allows for a law enforcement officer to take someone into custody who has an advanced healthcare directive without needing to meet that imminent insubstantial threat. Once the law enforcement takes the person into the protective custody, they must deliver them to that medical practitioner to complete that examination that I had started talking about. So that is the whole function of this protective custody statute. It's to be able to deliver the person for evaluation. I have observed and have heard from my interaction with this statute and this process is that there is some confusion or perhaps processes that are occurring in practice that might be disconnected with the law. For example, I've heard that some law enforcement agencies may require a blue paper to be completed before they can take someone into protective custody, and that's not how the statute is designed. I've also heard frustration on the part of law enforcement to bring someone into protective custody, deliver them to the hospital, then to have the medical practitioner say, thank you, we don't think the person meets criteria. So that may be a stress point in the statute of how things are working right now. Any questions on protective custody or that element of this process?
Committee members, are there any questions? Not seeing any hands.
Okay, thank you. And Ms. Ranch, if I could just go back to the section 3863 now. So I'll go through what happens after the application is completed and we're doing the certified examination and there's a assessment of likelihood of serious harm as part of the elements there. The next step after that practitioner says, yes, I am opining that there's no resources, the person's mentally ill and so forth, is to seek a judicial review and endorsement. And that's in paragraph 3 of this section. So what the endorsement does, and this is again, section 3 of the blue paper, is that it authorizes a person to be admitted to a psychiatric hospital. That is what the Superior Court Justice or judge of the district court or other judicial officer or justice of the peace is saying, I've reviewed this application and I'm going to sign it and endorse it for a person's admission to a psychiatric hospital. There's some timing considerations here, and that's laid out in detail in this statute. And this is actually what was part of the analysis by the law court in the most recent decision in the AS versus Lincoln Health decision, is what procedurally happens during these time periods. Because as you may have heard, just because someone arrives at emergency department and a medical practitioner there says, yes, this person needs to be psychiatrically hospitalized, that doesn't mean there's a bed that's available at that moment in time. And these processes in section 3 describe what would happen if a bed is not available, who is responsible for what, and the timing on that. So there's these periods of time, 24 hours and 2 48-hour periods. You'll see the definition of likelihood of serious harm comes up again in subsection 3D. So if they're there for 24 hours, there's no psychiatric bed available, and the emergency department is asking to hold the person for an additional period of time, there continues to be an evaluation. And this is a consistent theme throughout this statute, is that along their way, there's multiple points in time where there's an evaluation of likelihood of serious harm due to mental illness, which is important for if you are going to be considering changing that definition and thinking about how it influences the other sections of the statute. So even during these periods of time while someone may be waiting at an emergency department for a psychiatric bed to open up, there's consistently these evaluations that are happening. And does this person continue to meet this definition? Okay, if the bed is located at a psychiatric hospital and a judge or judicial officer has signed off on the admission, then the patient may be admitted to a psychiatric hospital, presuming, of course, that hospitalization is still warranted. If not, they must be discharged. Another section I want to point out is that once they're admitted, and this is section 7A of 3863, there's what is commonly referred to as the 24-hour certificate. So as there's yet again another evaluation on whether someone is continuing to meet criteria to be in a hospital, including likelihood of serious harm. That's section 7, section 7, post-admission examination, and that's after the admission to the psychiatric hospital. And if that can't be verified or certified, the person again must be discharged. If you scroll to paragraph 5A, I believe, and go back up, please. There's yet again another consideration. Once the person's at the hospital, they've been there 24 hours, it's certified that they still meet the criteria. There's again another analysis. Can the person be here voluntarily and admitted that way? And if not, if they continue to need hospitalization, then that's what paragraph 5A is, and that's where the application is going to be made to district court. The timing on that, sometimes we hear the terms or the timeline is 72 hours. It's actually within 3 days, which is 72 hours. However, there's a paragraph or an exception for what happens if that third day falls on a weekend or a holiday. So multiple checks in the statute of making sure the person is still meeting the criteria. That's emergency process kind of 101. And if anybody has questions about that emergency blue paper process, I can pause here if needed.
Yeah, let's take a pause. And Peggy, could you end the screen share? That's really thorough and helpful, Ms. Moynihan. I just want to check in with committee members and see if there are, if this is helpful to committee members and if we should continue to proceed or how are people feeling? Ms. Moynihan, can you let us know where you would go next in this presentation?
The next step is just what happens after a district court application is filed. And I can go faster through this section if you'd like.
Yeah, let's do that. And let's do it without the screen sharing. I feel like this is so dense and we are absorbing, but it's a lot to absorb.
I absolutely understand. And I think that's part of the consideration too, is that these are very complex and detailed statutes, and making what seemingly appears to be a simple change would have an effect on multiple sections of the statute. So I understand that that perspective. Once an application is made to district court, and if you'd like to look at the statute, this is all under section 3864, that's the white paper. There's an application process, there's a notice of hearing, there's appointment of counsel, there's an appointment of an independent examiner who does an evaluation. There's a date that's set for hearing. It has to be within 14 days unless there's good cause to extend that. And I want to point out again, this definition of likelihood of serious harm comes up in this process with before the hearing with the independent examiner who's doing the evaluation. Part of what that evaluation must include, the report, is whether the person is presenting a likelihood of serious harm, and instead of thinking about hospitalization, whether that person might be a candidate for the progressive treatment program. So here's where you have, this idea of having a definition that's applicable to both processes. It might not make sense in practice or in the context of the statute to have an examiner opine on, this likelihood of serious harm, but have it somehow be distinct in making an opinion on hospitalization and an opinion on PTP appropriateness instead. That examiner, like the medical practitioner earlier on in the process, is able to make personal observation, take into account history from other sources. So the whole picture is looked at with regards to the patient. You get to hearing, and I wanted to just point out for, volume wise, our office handles over 1,000 applications per year at our hospitals. And we've got 2 state hospitals and 8 non-state hospitals that do this work. And these, we are in district court every single week, every Wednesday, every Friday on all these hospital cases. And I did want to mention that not all of these cases reach hearing. I know that was a concern at the public hearing, that if you get someone into a hospital on a blue paper, that they're going to be perhaps stuck there for a long time. Many of these cases get dismissed before hearing, and that signals that the person has either become well enough to leave a hospital or has decided to stay voluntarily. So we do handle a large volume of these cases in our office. When we get to hearing, we are required to demonstrate our evidentiary burden includes presenting evidence that due to recent actions and behavior and due to the patient's mental illness, the patient posed a likelihood of serious harm. So we're going back to this idea of recent actions and behavior that would support the commitment. These findings are clear and convincing, and those are what the court needs to make as part of its evaluation, is whether the clear and convincing evidentiary standard is met. The court may then issue an order, and that order can be up to 4 months in the first instance, or a year, depending on if it's a request to continue a current order. Court can dismiss the application. I've had cases where the court has said, nope, I don't think this is enough evidence to impose this commitment on the person. Interestingly enough, our statute also allows the court to, as an alternative, order the person to participate in a progressive treatment program. I've never seen that occur where we are there for a hearing on commitment and the court has decided, you know what, no, I don't think that standard is met. I think that this person instead meets criteria for the PTP. Again, that's going back to this idea of a different definition and evidentiary requirement for the PTP. Finally, the other 2 places in the statute that are in practice where likelihood of serious harm comes into play is regarding the imposition of involuntary treatment, and that is medications while at a hospital. That is both in section 3864 7A and 3861.3. There's these 2 parallel processes in the statute allowing for treatment. And those processes also take into consideration this definition of likelihood of serious harm. That is all I was going to present on how the statute functions and what the process is. If anyone has questions, I'm happy to answer those. And I'm also happy to get into some of the other legal concerns with this bill.
Committee members, are there questions related to this information? It's a lot. I'm not seeing any. Go ahead, Representative Babbage.
Thank you, Madam Chair. Thank you, Ms. Moynihan, for these clarifications. Can you explain to me the reasoning or that you think that the courts have not used the referral to progressive treatment as an option?
Sure. So that is in the part of the statute regarding what, and that's in 3864. And let me just turn to that so I have it right in front of me. Where at a commitment hearing, the court may have the opportunity, it's written into the statute, to instead say, I'm not going to order this person's commitment today, but I do think that the person could participate in the progressive treatment program. I think part of the reason I've never seen this occur, I'm not sure the court is aware of it, and also to put together a PTP plan, and going back to what I had said about section 3873A earlier, it requires a fair amount of work to develop an individualized plan. And the statute doesn't say the format of that plan, but what the courts are accustomed to is a plan that's usually 4 to 5 pages long. There's a list of the patient's responsibilities, a list of the provider's responsibilities. And if you were in the middle of a court hearing on a commitment, I think it would be difficult for a judge to say, you know what, I think this person needs to be on a PTP. But at that point in time, you wouldn't have a PTP plan developed for the person. You wouldn't have already secured the outpatient providers. You wouldn't have already discussed it with the patient. So I think that may be, I don't necessarily understand, or I haven't looked at what the legislative history was on adding that provision as having an option for judges to make that ruling instead. I think as a practical matter, it would be a challenging ruling to make in the absence of an already developed plan.
If I have one follow-up, Madam Chair.
Go ahead.
My understanding is that a progressive treatment program is finite, a year-long program. Is that right? And my question would be, has anybody ever been reassigned?
Yes, absolutely. We have, the statute allows for the admission of an individual to the PTP for up to a year in the first instance. And then there's a provision on extensions and modifications or dissolution. So those are other possible motions that can be made with a plan. But an extension can be requested for up to an additional year. Our office has interpreted that as, you get one extension. That said, there have been instances where somebody has been on the plan for an initial year, has an extension for a year, and there's concern in the community that this person will need to remain on a plan. So what happens after those 2 years is a new application is filed. There are a handful of individuals in our state that I'm aware of.
I'm just going to interrupt you there because I think if we go too far down into the path of renewal of PTPs, we're going to lose our focus on the definition that's the subject of the legislation. So I appreciate your willingness to provide us with the information. It just may be a little bit more than we can absorb right now. I see that there are some other questions, so let me just turn to Representative Harnett.
Thank you very much, Madam Chair, and thank you very much, Ms. Moynihan. And this question probably has an obvious answer, but we've just been hit with lots of information. But one of the things you're saying, and tell me if I'm wrong, is simply removing that introductory clause for the purposes of section 7873A in the definitions regarding likelihood of harm has ramifications throughout the statute, because now D is going to apply every single time that phrase is used, be it involuntarily medicated, involuntarily committed, and a whole host of statutes that could have serious implications regarding deprivation of liberty. Is that fair to say?
Yes, that is correct.
Thank you.
And then I have a follow-up on that. You, at the end of your presentation, you had said that there are other legal concerns that you had with the bill. And could you just list them for us, please?
Yes. In the letter from the Attorney General, it just highlighted the need to pay attention to the constitutional issues at stake here. Those would be the legal concerns. I don't have I'm not able to predict whether this change in the legislation would sustain a constitutional challenge from somebody who's concerned about the language. I don't know what our court would do, but just keeping in mind that our court has signaled in conjunction with our United States Supreme Court that these involve significant deprivation of liberties. They require due process protections that are commensurate with what level of deprivation is occurring. And, hospitalization is significantly more of a deprivation of liberty than putting someone on the progressive treatment program. I don't think there'd be any disagreement on that from different, persons with constitutional expertise. Our court has noted that,
I'm just going to interrupt you there because I feel like we're getting more information than we can absorb. So there's the constitutional issue. Are there other issues, concerns that you wanted to raise?
Sure. Yes, and just they are all kind of related. I think that the main ones are just to be very mindful of the constitutional considerations when thinking about the language in this bill. And I think that's where it's helpful to kind of understand the entire scheme and how this definition repeats itself throughout. I also wanted to point out, thinking about section C, or the definition of C, and how that I think has been overlooked a little bit in understanding what can serve as a basis to get someone into a hospital. And just making sure that the standard is clear and not based on, language, that the language is clear and appropriate and less vague than perhaps what is in D. D was designed, in my understanding, to be applicable just to the PTP. So, transposing that language by just striking out that qualifying language in the beginning of D to a hospitalization setting may not be effectively the way to go about making changes in this statute if it's not clear, what kind of evidence needs to be presented at these hearings, how to tie recent behaviors to this definition. I think the words are really important in looking at whether these exact words are going to be accomplishing the intent of this legislation. Just, in general, making sure that the language can be reasonably interpreted by everybody who's affected by this process. And there are many parties that are involved in these processes, and any kind of unintended consequences for making these changes. I think those kind of summarize all of the potential legal concerns here.
Great, thank you. And that I feel like we just had a complete law school course. And so we really appreciate your information. If you could stay on the panel just for a moment, we have one of the attendees, Dr. Skinner, has had his hand raised, and I'd like to bring him in because I think that he has something that he would like to share with us. And then as committee, we'll regroup and decide where we're going to go from this point now that we've had a lot of additional information presented to us. Hello, Dr. Skinner. Welcome to back to the Judiciary Committee. And before you start to launch into what you were going to say, can you just give us a little framework of what you'd like to speak with us about, so that I can figure out how it fits in with the overall work that we're doing?
Yes, thank you, Madam Chairman. And greetings to all the distinguished committee members. So I had a couple of points. I initially raised my hand when you were discussing the protective custody statute, but that's sort of passed. And I wanted to talk a little bit about the civil liberties implications of this language, and to also offer a suggestion.
Okay, if you can briefly take us through that, we would appreciate it. And I know you have a lot to share with us. We have a limited capacity to absorb a whole bunch of information. So go ahead.
Yes, I appreciate that this is pretty turgid material. So I think the civil liberties concerns are very, very valid. But they need to be viewed in context. So one of my thoughts about that is that if you're going to deprive somebody of civil liberties by putting them either in an emergency room where they're not allowed to leave, or in a psychiatric hospital which has locked doors, that there ought to be good cause for it. And from a medical point of view, we're always looking at things from the point of view of what are the risks and benefits of alternative courses of action. So if somebody has been brought to the emergency room.
Point of order, Madam Speaker.
Go ahead.
Thank you. I understand that I'm new, but I'm trying to differentiate between public hearings and workshops. And I thought that the purpose of a workshop was that we could discuss amongst ourselves the merits of the bill versus having proponents come on and speak. Maybe you could clarify that for me?
Yeah, I thought that Dr. Skinner was going to aid us in our discussion, but if committee members are ready to move on to discussion and a vote, then that is totally fine with me as well. I'm trying to serve the needs of the committee here. Representative Evangelos, go ahead with your.
Thank you, Madam Chair. Representative Thorne, sometimes we invite people in to help us understand dynamics of the bill in work session. It's not considered inappropriate. And I specifically asked both Dr. Skinner and the attorney for disability rights to come to the work session, help us out if we needed it at the hearing. So it's at the discretion of the chairs, but it's not considered inappropriate. So I just wanted to clarify that. Thank you.
Very good. That was just my interpretation. Thank you, Representative Evangelos, and thank you, Madam Chair. I just realized that we were in an expediency mode, and it just seemed that this is going beyond what we need to be presented. I think most of the committee members, for the most part, are prepared to make a vote. So I'll wait until the appropriate time is made for somebody to make a motion to vote on it. Just thank you for allowing me my point of clarity. Thank you.
Yeah, no, I appreciate it. And I think earlier where there were less complex bills, we were moving more quickly. This is a super complex matter, but I also, if the committee is ready, well, let's let Dr. Skinner speak for a few more minutes, and then we'll excuse our guests and return to our work as a committee and see if the committee is ready to vote. Go ahead, Dr. Skinner.
Thank you, Madam Chair. I appreciate the committee's interest in brevity. So essentially, if somebody's civil liberties are going to be deprived, we have to have good reason. And so with thinking in the ER as a psychiatric physician, what is this person's ability to exercise their liberty if they're psychiatrically decompensating and they're not able to fulfill their work roles or their family roles and so forth. Also, if the person is not hospitalized and they're let go, what's the likelihood that they could suffer a worse deprivation of liberty in jail? And lastly, it's not incomparable to the loss of liberty that one experiences when one is in the intensive care unit of a medical hospital, where one is chemically paralyzed and has a plastic tube in one's trachea and can't really move or speak until their medical condition permits the removal of those care devices.
I think you're moving a little beyond the scope of this bill, Dr. Skinner.
Okay.
We appreciate you being here. Committee members, are there questions for Dr. Skinner? Representative Libby?
I don't have a question for Dr. Skinner, but I certainly would like to address a comparison to an ICU patient. I have had many folks come to the ICU that have come, it was brought up and I plan to speak to it. Many patients who have come to the ICU long after they should have, and that was their right to not get treatment. And I am extremely loath to pass a bill that will skip over the civil liberties of the citizens of Maine without due process. This feels very minority report-ish to me, and I will certainly be voting ought not to pass. And I appreciate the intentions of the sponsor, and I say that as someone who had a close family member commit suicide after many, many attempts. And if I could change the past, I would still not pass this bill.
Thank you, Representative Libby. Other questions for Dr. Skinner? I am not seeing any. And before I excuse Ms. Moynihan, are there any additional questions for Ms. Moynihan? I am not seeing any. And there is one other person who I would like to bring onto the, actually, yeah, one other person I would like to bring onto the panel because it's a person who I have a question of, and I promise committee members to be brief, and that's Ms. Shaughnessy. Ms. Shaughnessy, could you, when you are able, thank you.
Hi.
Hi, welcome to the Judiciary Committee.
Thank you.
Briefly, I have a specific question for you, which is, have you been working on language that would potentially address the sort of find a way to address this legislation that is different than the language proposed in the bill?
Yes, I've been doing a little bit of research, and there is language directly from SAMHSA, the federal agency overseeing mental health and substance use treatment. There's some language that they put forward as a policy suggestion for committees just like yourself that are searching for language to use. I do have that language, and I also have been hearing from or talking with the Advocacy Treatment Center or Treatment Advocacy Center in DC, and in looking at New Hampshire and Vermont, which are our close neighbors, apparently Vermont has very good statutes that they would consider sort of, some of the state of the art as well. But I'd be happy to share that with you. I do have some information that I put together. If you'd like me to share that with the committee, I could do that. I'm not sure how we do that.
Could you please email it to our committee clerk?
Yep, I can do that. Is that to
just JUD.
Susan?
Yes.
You can just send it to JUD at legislature.maine.gov.
Okay.
It'll get
Okay. I will do that right now.
Thank you. And we are going to excuse you from the panel and take you back to the attendee list. Thank you
very much.
Senator Sanborn.
Thank you, Senator Carney. I feel as though making sure that we have the right standards for involuntary commitment is really, really important. And I heard some really compelling testimony that people who really need help aren't able, and their loved ones aren't able to get them that help until they have become extremely sick. I don't think the language we have in front of us is the right language. And I think that we owe it to the folks in Maine who struggle with a mental illness to get this right. And so I won't make the motion at this moment because I don't want to cut off the opportunity for my colleagues to weigh in. But I would ask that we consider tabling the bill so that we can review Ms. Shaughnessy's suggestions and the language from other states, the language that she just referenced, that may provide us with the ability to catch people a bit before they fall to a place where we may not be able to offer them assistance at all because they may have passed away. So that's how I would like to proceed, even though I know that we have a lot in front of us. I really think this is worth our time and our energy as a committee to give it a few days and see if we can find language that would save people's lives. Thank you.
Representative Thorne.
Thank you, Madam Chair. I'd like to take a page out of Senator Sanborn's playbook and make a motion to end debate on this. I don't think anybody's going to change anybody's mind on this. This is very similar to what occurred last night late in debate. Unless somebody feels otherwise, I'd like to make a motion ought not to pass.
Can I just ask you a question, Representative Thorne? Because I don't feel like we've actually discussed this at all personally. I feel like
I disagree, Madam Chair. We discussed it in great detail during a public hearing, and we've been discussing it now for well over an hour, I believe, is what we have on the books for it. And I don't think the debate is coming from within the committee. I think the testimony that we've heard today, again, feels more like a public hearing session than it does a work session. And we've heard different proponents of this bill speak on it. And I don't know that anybody's on the fence on this, or that anything that Ms. Shaughnessy is going to present is going to change anybody's opinion on this. I mean, it's a lot of details, it's a lot of verbiage, but I think the nuts and bolts of it is either you do want it or you don't want it. And we've established the conditions and all the different nuances of determining whether or not somebody should be committable, and the definitions of those and the conditions surrounding it. So I think we're just kind of driving around and around the barn here, but that's just my opinion. I know we all have our opinions, so if somebody feels differently, I just wanted to make that motion. Thank you.
Yeah, I would just point out, I don't think Ms. Shaughnessy was actually a proponent of the bill, but Senator Sanborn?
Madam Chair.
Thank you, Madam Chair. I move to table. I move to table, which is non-debatable. Thank you.
Is there a second on the motion to table?
I second Representative Thorne's motion, ought not to pass.
Okay, there's a second.
Madam Chair, just for a point of clarity, I do have Ms. Shaughnessy down as testifying for in the public hearing.
That is correct. However, the Assistant Attorney General was Ms. Moynihan, who I was referring to. Okay, so we have Representative Thorne's ought not to pass, and then we have a non-debatable motion to table by Senator Sanborn. And I was asking if there was a second on the motion to table. And Representative Babbage has seconded the motion to table. It's a non-debatable motion. And so we'll move into a vote on the motion to table. And thank you very much, Ms. Panett. And so the pending motion is a motion to table LD 785. And I would just ask folks to take their hands down until we're done with the vote, and then you can re-raise your hands.
Madam Chair, do you want a roll call on this vote?
Yes, please.
Okay, thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett, and thank you, committee members. That brings to a close our work session on 785. And I feel that it would be appropriate for the committee to take a 5-minute break. Representative Evangelos has had his hand up though. So Representative Evangelos, go ahead.
Thank you. Since the motion was non-debatable, I didn't raise it, but Mr. Voitovich had his hand up, and my suggestion was going to be, since it is tabled, that if the problem from my head on this bill is that Dr. Skinner and Mr.
We've-
Voitovich.
We've
I'm making a
tabled
suggestion.
the motion and ended the work session.
Senator Carney, you said people lower their hands and then they can raise their hands back up. So I'm just doing what you said. Let me make my point. It'll take 20 seconds. Mr. Voitovich had his hand up. We asked him to participate in the work session. He wasn't recognized. So I just want to make sure when we go back in that he's given the opportunity like Dr. Skinner was.
Absolutely. We will invite, because we'll be resuming our work session, we'll re-invite everybody who was originally here for the work session today. And thank you for raising that point. Committee members, would you like to take a 5-minute break? Yes, I'm seeing some yeses, and I know that Peggy and Soupy probably would also really appreciate a break. I'm sorry for excluding you from the request. So let's return at 11:25, everyone. And please remember to deactivate your audio and video. Wow, we are such a prompt group today. Let's see. Welcome back, everybody. We're going to continue our work sessions. We promised that we would finish our work by 12:30 today. And so we'll move on to our next work session. And that is LD 868, an act to provide consistency regarding persons authorized to conduct examinations for emergency, involuntary commitment, and post-admission examinations. It was introduced by Representative Reckitt. And Peggy, can you please take us through sort of a summary of the bill analysis, and then we can let you know if we have need to do a deeper dive anywhere?
Great. So I think it was really good that Molly Moynihan kind of walked you through that whole process, because the definition of medical practitioner, a medical practitioner is the one who does that initial evaluation about admission for somebody into an involuntary commitment process. What this bill does, it amends who does two others of those evaluations. Section 1 is the post-admission examination, the 24-hour examination, and then the post-admission discharge. And this is a person who makes the finding that the patient no longer meets that likelihood of serious harm definition. So the medical practitioner who makes that first initial yes, let's go down this road for this process, is that's a defined term, medical practitioner, and it means a licensed physician assistant, certified psychiatric clinical nurse specialist, certified nurse practitioner, or licensed clinical psychologist. That's a kind of a broader category. In these two evaluations, the post-admission examination, the 24-hour, person's been admitted, re-looking at the person to make sure that they still meet that likelihood of serious harm, this is limited to the staff physician or licensed clinical psychologist at the facility. And the bill would change that to medical practitioner, so expand who can do that examination. And the same with section 2. This is the post-admission discharge. Again, it would change it to medical practitioner who would be making that assessment. And there is one, if you make those changes, then you will need to make one more amendment change to be consistent with the certificates that these folks fill out.
Thank you.
Is that enough?
That is enough for now. I had one other question for you, which is that during the public hearing, it just started to snow. That's why I'm distracted. I'm looking out my window. Some of the folks who spoke at the public hearing suggested that we might want to include some sort of reference as to where that term medical practitioner is defined, but I know there are rules about what we do and don't include in the statute. Can you update us on that a little bit, please?
Yes, so the definition of medical practitioner is in section 3801. And I'm trying to figure out if and it says as used in this subchapter, unless the context otherwise indicates. And I'm looking at these two sections are in subchapter 4, which is a different, I believe. No, that's still the same chapter, subchapter, I believe. Let me just double check that. So if it's still the same subchapter, then you don't need to cross-reference it, because we've already been told by the statute that this term applies throughout the subchapter. If we're actually working in a different subchapter, then we can do a cross-reference.
Yeah, and I think it's all within subchapter 4 hospitalization, I think, so.
I think you're right.
Okay, awesome. Thank you. Committee members, questions for Peggy? Not seeing any questions. Does any committee member have a motion on this legislation? Representative Harnett? Oh, Tom, we're not able to hear you.
Thank you, Madam Chair. I would move ought to pass on LD 868 as amended, as it brings consistency to the statutes involved in the process at hand. Thank you.
Well, second.
Thank you. And is the motion and the second, does it include the third place where the change needs to be made that Peggy pointed out?
Yes, I thought that was the amendment. I apologize if I didn't.
Oh, okay. I'm sorry. I'm probably losing track. I think it's my fault, Tom. Thank you.
So that's ought to pass as amended, right?
That was my intent.
Okay.
Thanks.
Perfect.
Okay, motion by Representative Harnett, a second by Representative Moriarty. Committee members, is there discussion on the motion? Go ahead, Representative Thorne. Or Representative Libby? Somebody has their hand up.
I do. Apologies. I am just hopping on the Zoom. Can somebody catch me up on where we are, please? Just briefly.
Of course. You have adopted Representative Thorne's name as the first point. Secondly, we are on LD 868, which is changing in a couple of places the phrase physician or licensed clinical psychologist to the term medical practitioner, which is defined and used other places in the statute, which is subchapter 4 of Title 38B, 38A.
34B.
34B, excuse me.
Thank you.
Do you have any questions, Representative Libby?
Just a reminder of the bill number, please.
868. Sorry.
Thank you. I'm all set now.
All right, and then a discussion. I see that Representative Evangelos has his hand raised. Go ahead, Representative.
Thank you, Madam Chair. I actually had a couple of physicians contact me and raise the issue of, and I'm only asking this to see if Peggy could help me out, that their concern was around the hours of training and residency that the lower level of practitioners have had versus the higher level physician or psychologist. They're claiming that the residency difference was up to 80 or 90%. And they raised concerns in that regard. Peggy, did we hear any information about how much training and residency the practitioners have versus the higher level physicians?
I don't think, I certainly didn't write down exactly what that was, if anybody presented that. I mean, that is definitely a change, is that it's a different category. It expands who can make these decisions, do these evaluations, and they're not probably the highest level right now are that are doing any of them, even in the medical practitioner, are these physician or psychologists that are usually on that are on staff.
I don't have the exact numbers written down, but the doctors that called me said that they're required to do like 16,000 hours of residency versus maybe 500 hours for some of the others. So they had concerns around that. I just wanted to point that out to the committee. Thank you.
Thank you, Representative Evangelos. Committee members, is there any other discussion? Is the committee ready for the vote? Appears to be so. Thank you very much for joining us, Ms. Panett. You can go ahead when you're ready.
Thank you very much, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
Yes.
Representative Newell votes yes. I will call the absentees. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 9 members in the affirmative, 2 members in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. So the ought to pass as amended motion carries a 9-2 with 3 absences. And for those who voted against the motion, could you please let Peggy know what your report is?
Ought not to pass.
Same thing.
Okay.
Based on the training standards, that was my grounds. Thank you.
Thank you, everyone. That brings to a close our work session on 868. And so we are going to move on to LD 861. This is a resolve directing the Department of Health and Human Services to contract for assessments for involuntary hospitalizations. And on this one, I would like to move to table the bill because this is a challenging situation, and the various parties who would be directly impacted by it would like some additional time to try to look for ways to address the situation. Representative Evangelos?
A motion off the table.
Thank you. Is there a second? Seconded by Representative Harnett. And committee members, let's see if we can just do this by a show of hands. Please raise your electron. Oh, Tom?
I would just use my wrong hand. I'll raise my electron.
Yeah, no real hands. Someday we'll be able to do that again. But please raise your electronic hand if you're in favor of the motion to table. And Representative Evangelos, are you you're in favor of the motion as well? Okay, great.
Sorry.
No, that's all right. And then Representative Libby, could you please weigh in because we can't see whether your hand function is working or not. Yes. And then Senator Sanborn, same for you. I don't know if you're participating or not at this point. I think Senator Sanborn is not present. So,
Madam Chair, I have a question.
yes.
Just for my notes, I didn't get who actually made the motion to table. Was that yourself or
I did.
Was that Evangelos?
Mm-hmm.
And the second was by?
I believe it was Representative Harnett.
Thank you.
And so it looks as though all have voted in favor of the motion. I know some hands have gone down, but if that is not the case, please let us know. The exception being Senator Sanborn, who's not present. All right, great, everybody. Thank you very much. That closes the work session on LD 861. And we'll move on to our next matter, which is LD 747, an act regarding civil mental health evaluations of former criminal defendants. And I believe that Senator Keim has joined us. So I'll give her a moment to introduce herself.
Thank you, Madam Chair. Good morning, everyone. Sorry, I'm not able really to be on much today. So but my name is Lisa Keim, and I represent Senate District 18, which is Northern Oxford County and 2 communities in Androscoggin.
Thank you very much and welcome. Representative Moriarty, your hand is up. Did you have a? No, okay.
Just haven't taken it down yet.
All right, I just took mine down too. I forgot about it. Okay, so we're moving on to the work session on 747. And Peggy, if you would be so kind as to give us your bill analysis, please.
Sure. So I think this bill is confusing. The purpose of the bill was to, the population you're looking at is folks who are incompetent to stand trial, IST. So they had at some point been charged with crimes. Current law says that if they remain incompetent to stand trial and there's not really a chance that they can be restored, if they were charged with certain serious crimes, then they can proceed, they can be go through an involuntary commitment. And I think the purpose of the bill was to give the Commissioner of Health and Human Services an opportunity to make sure that somebody who has been charged with a crime could be, they pose a likelihood of serious harm, that they can be start them in the process for involuntary commitment, even if they're out in the community because they've been not, so there was an opportunity, they were hoping they would be able to be restored to the ability to stand trial. So, and they haven't been, and they won't be. And the department, after listening to the hearing and listening to folks, the department has worked with other parties, and I believe one of them is Attorney Netto, and they put together an amendment, which I tried to send out to you last night, so I hope you got it. And I think it makes more sense to look at that amendment because that is intended, that's really intended to carry out their purpose. But I'm trying to see who's here on the, I think Dr. Miller is from the department. She might be better to speak to this amendment. I realize that might not be the exact protocol you were expecting today.
No, I think that gets us exactly where we need to be. Thank you very much. So yeah, so we did receive an amendment and also received some concerns from the judicial branch. And so let's have those who were working on the amendment weigh in and discuss with us the impact of the amendment. And I think that's a good place to start. And Dr. Miller, I am going to move you and also Molly Bogart over to the panel because I think you were both had a role in the amendment. Thank you for joining us, both of you, Dr. Miller and Ms. Bogart. And if I've brought in the wrong people, let me know. But we would really appreciate if you are the correct people, if you could walk us through the proposed amendment.
Sure, and I will defer mostly to Dr. Miller here, but I'm here if you need me.
Thank you. Go ahead, Dr. Miller.
Thank you, Senator Carney and Representative Harnett and members of the Judiciary Committee. After the public hearing and subsequent conversation with Attorney Tina Netto from the Maine Association of Criminal Defense Lawyers, I worked to suggest this amendment in hopes of clarifying some of the questions that arose. So perhaps I should start with a more succinct version of the intent of the original legislation. There are situations in which the department is ordered to undergo a blue paper assessment under Title 34B, in which it did not really make sense because these were individuals who had already been successfully living in the community. And the current statute mandates that the department undergo those proceedings. And so the larger intent, sort of to step back and look at the bigger picture, was to not mandate those assessments in situations where everyone understood that it was not needed. And so the proposed amended language does a couple of things. One is that it separates out anything related to a defendant who has been found both incompetent and non-restorable, because this section of the statute was a bit complicated to begin with. And so by separating out those who are found non-restorable, the hope was that that would make it easier to understand what exactly is required. And then we have also added back in some language indicating that the 34B assessment would apply only for individuals who were charged with certain violent crimes, but changing that language from the court shall order the 34B assessment, the blue paper assessment, to the court may order the 34B assessment. And that allows some discretion there when a judge has already approved that someone could be placed in the community and those safety concerns have been addressed. So perhaps I should stop there and wait for questions, although I'm happy to add more detail if needed.
I'll start with the question because I lost you there. So when you're speaking about adding back in the reference to the violent crimes and also changing the shall to may, is that included within the new subparagraph 5A on the amendment, the finding of non-restorability, or is it included in the existing section 5 that was kind of the subject of the original bill?
The existing section 5, the statute as it currently exists under section 5 included those generally violent charges as a predicate for when the court shall order a section or a Title 34B blue paper assessment. And so under the bill, under LD 747, the department had originally proposed removing that language. But after reflection and hearing comments at the public hearing, we realized that did not truly meet the intent of what we were trying to accomplish. And then the second piece of your question of changing the court from shall order to may order, yes, that is included under the new section 5-A, the proposed amendment that was just sent last night.
I think that's in paragraph B of 5A.
Thank you. I was having a hard time finding it. Thank you. Committee Thank you very much, Dr. Miller. Committee members, are there questions for Dr. Miller? Representative Harnett?
Hi, this is often the case. I'm a little confused. I'm looking at the amendment and looking in section 5A. And I don't see where the word may was added, or are you just referring to the fact that the word may is already in there?
So subsection 5A is all new, I believe.
But there is
5AB. Whoops.
Okay.
Yeah, there's I think that's, I was confused too, Representative Harnett, which is why I asked the question. So there's first of all, does any committee member not have a copy of the amendment?
I don't.
Okay, so let's start there. Peggy, would you be able to screen share the amendment, please?
I apologize. I was looking at 5A, not 5-A. 5-A is the amendment. My bad.
Yeah, it's confusing. And I think also, yeah, could
So
you, yeah, is that okay, Peggy? Thanks.
So I think there's no change here. This is existing law, 5A. And this is what the bill amended. It put language in here, but instead all this language here is removed from 5A and is added. Oh yeah, it helps if it's in color, huh? This is all new language. So some of it is just transferred there. Here, I'll do this. And some of it is new, but I think it's intended to carry out the original idea of the bill. So this is Dr. Miller will correct me, this is basically the current law with regard to people who are incompetent to stand trial. They've been found incompetent to stand trial. They've been found not to be restorable to competency, and their charges are the more violent crimes. So these crimes, sexual assaults, and I don't remember what these are, but anyway.
Yeah, I think arson is in there as well.
Okay, right, that would be the 800s. B is the people who are in that situation, except their crimes were not those high level, those more violent crimes. And here's where it says the court may notify the appropriate authorities who may institute civil commitment.
If I could provide one more clarification.
Yes.
5-A sub A has further amendments from the current statute. 5-A sub B and sub C are exact copies of the current statute, simply moved into another section for clarity.
So those are all, that's current law.
Yes.
We'll make them green.
Mm-hmm. And so, Dr. Miller, can you one more time walk us through exactly what is new then in 5-A and subparagraph A?
Yes, so in 5-A sub A, under the first sentence, after you get through that, if the defendant is charged with certain charges, unless they are subject to an undischarged term of imprisonment, court may order commissioner to commence proceedings. Current statute says the court shall order the commissioner to commence proceedings. And then the subsequent sentence, if the defendant is not placed at an institution, etc., that is all new language. And the intent of that new language is to clarify that if someone is living in the community, if they're not at an institute for the care and treatment of mental illness, And there is a need for an emergency blue paper assessment that it must be treated like an emergency. So essentially the commissioner should receive some understanding of why there's an emergency situation, because currently in statute, when we get notice of these individuals, we may not know where the person is living anymore or how to contact them. And so we have an order saying, undergo a blue paper assessment to see if this person needs to be emergently committed due to a serious risk of harm. And yet it takes days or sometimes even weeks to make that connection and make that assessment happen. And so in the very rare instances where someone's in the community and there is an emergency, we want to be able to act quickly.
Thank you. I think that was helpful, but let's turn to the committee. Peggy, could you end screen sharing for a moment, please?
I think I can.
Thanks. All right, committee members. Are there additional clarifying questions first before we get to the policy underlying this amendment? Go ahead, Representative Thorne.
Thank you, Madam Chair. I believe that Tina Netto is in the waiting room, and if it's possible, I'd like to bring her in.
Thank you. I will do that right now.
Thank you.
Did you have an additional question that you'd like to ask her when she arrives?
Yes. I mean, we can continue with the line of questioning that we're on, but just as we address this, I also want to hear from Ms. Netto.
Okay. Thank you, Ms. Netto. Welcome to the Judiciary Committee. Representative Thorne has a question for you, and I think we'd also like to generally hear on you with regard to the proposed amendment. Go ahead, Representative Thorne.
Thank you. And Ms. Netto, if you would, please, we're currently discussing LD 747, which is an act regarding civil mental health evaluation of former criminal defendants, of which you spoke on last week. Specifically, what we're talking about is the emergency process of determining that a patient is deemed to be blue paper worthy. I wonder if you could talk on that a little bit to clarify what your interpretation is.
Sure. Well, and thank you, Representative Thorne. I addressed some of the issues I had with the initial bill last week, which were many. In discussing with Dr. Miller at length about what the actual intent was, we did talk about ways to potentially clarify. And I know there's going to be probably some Ms. Reinsch help here with the drafting to make sure it's all compliant. But this paragraph in 15 MRS 101D is huge, and it covers a variety of circumstances involving competence. So we wanted to focus, from Dr. Miller's perspective, precisely on the type of defendant who has been found both incompetent to stand trial and non-restorable. She addressed that concern by pulling it out into a separate paragraph. She also re-added the class of crimes that could potentially trigger order for an evaluation, because the way the bill was originally presented, it could be any crime that somebody was found incompetent for, including very low-level crimes. So I support that re-addition of those class of crimes. The one thing I did like in the original bill that I think we could include here without diluting the purpose that Dr. Miller is trying to get to, which is essentially to be flexible once a client is found incompetent and non-restorable. If they're placed in other programming in the community, I think involuntary commitment is rather severe course of action. So this gives the discretion back to the judge to really listen to everyone and see where the client's at. But I do think the language that was in the original bill, I'm going to call it limiting language, is if there is reasonable cause to believe the defendant poses a likelihood of serious harm due to mental illness. I think limiting language like that really shows that it has to be, in the moment, and there's a likelihood of serious harm if this isn't done. I think that's an important limitation on the court's authority to order this. But I think the rest of the amendment that Dr. Miller has proposed does address a lot of the concerns we had on behalf of our clients so that they wouldn't get ensnared unnecessarily, but happy to clarify.
If I may, just kind of a off spur to that, Madam Chair.
Go ahead.
My concern, Ms. Neto, is with the civil liberties of the patient, where the standard, or I'll call it the determining authority to assess mental illness, is changing. Do you see that as an issue?
I don't really see it changing. I kind of see where you're coming from here, but there's been a finding of incompetence, a judicial finding that's informed by forensic psychologists usually who've done these evaluations. There is reference to the 34B statutes that kind of set the standards for involuntary commitment, some of the things you all were talking about just a bit earlier. So I don't see it as reducing the standard. I think understanding now very clearly what Dr. Miller's purpose is, the shall to a may makes a big difference for those clients. And there are quite a few actually who are incompetent, but not at Riverview and not incarcerated. So I make sure that if they're in a good place, we can keep them in that good place and not disrupt the services they're receiving.
Thank you.
You're welcome.
Thank you, Madam Chair.
Thank you, Representative Harnett.
Thank you, Madam Chair. Nice to see you again, Ms. Neto. How are you?
I'm good. I'm kind of making brownies in the other room, so it's a good day. Fridays are good days.
You make enough for the rest of the class?
Yeah, that's right. Someday.
You mentioned language in the original bill, which was on page 2, that reads, if there is reasonable cause to believe the defendant poses a likelihood of serious harm due to mental illness. And you said you would like it to be inserted in the amendment that is before us. And I'm wondering where you want that language and whether or not that is acceptable to Dr. Miller.
So on 5-A, sub A and B, I believe the language would be appropriate in both of those paragraphs.
Would it be at the end of those paragraphs, or where would it be?
I guess in the sub A, if the defendant is not placed at an institution for the care and treatment of people with mental illness, comma, and there is reasonable cause to believe the defendant poses a likelihood of serious harm due to mental illness, and the court orders the commencement of proceedings. I think that's where I would put it, but that's also me just riffing under pressure. And then with sub B, similarly, if the defendant is charged with an offense other than, let's see, it might not even belong there.
Okay.
Again, it's like a law school class. I'm under pressure in the moment. But I do think the limiting language in A needs to be there for sure. And Dr. Miller might be able to speak to that a little bit better.
If I might ask Dr. Miller to respond. Senator Carney.
Yes, go ahead. And Dr. Miller, you can go ahead.
Thank you. I would recommend under 5-A, sub A, at the end of the first sentence is where we should add that limiting language, because then it's clear that anytime the court orders commencement of 34B proceedings, that it should only be if there is a likelihood of serious harm, regardless of whether the person is in an institution for care and treatment of people with mental illness or not. I don't immediately see that it's needed in sub B, but I would be open to further discussion on that.
Thank you. Are
Thank
you
you.
set with your questions?
I think so. I think it would be a drafting question for our wonderful analyst. But it sounds, there is agreement. Thank you.
Representative Moriarty?
Thank you, Madam Chair. Ms. Neto, when you spoke last week, you told us that there was a bill pending before criminal justice. Is there any news on that front? And are you content to use this bill as the appropriate vehicle to make the changes discussed?
So now, thank you for the question, Representative Moriarty. Understanding the purpose of Dr. Miller's suggestions for this bill, like where it's coming from, and now with the amended version, I think fully fleshing out the intent and kind of melding it into reality. This bill I am good with. The bill across the hall, actually, even though it's not clear, addresses a different class of incompetent people. And it's kind of higher up in this big paragraph, which is incompetent to stand trial, but possibly restorable. So essentially, DHHS is asking for those people who are, I'm sorry.
Yeah. Just because we're trying, if we go into that bill, we lose our focus on this one. And I think
understand.
the question was, are you basically satisfied now that this doesn't create that concern that you were worried about? And Representative Moriarty, I jumped in because I'm worried that we're going to go on a sidetrack and get confused.
No, I didn't want to, but.
So can I answer just very
Go ahead.
quickly? The other bill is still extremely problematic. The bill amendments for 747 are acceptable from the MACDIL perspective.
Thanks. I think, did that address your question, Representative Moriarty?
Definitely, yes.
Okay, great. And I'm glad you raised that because that was an important concern to address. Thank you. I know that the judicial branch expressed some concerns about the prior version of 747, and I'm just going to bring Ms. Finn onto the panel so that we can ask her if this amendment addresses her concerns as well, or the judicial branch's concerns. Welcome back to the judiciary. I think you are with us just about every day, Ms. Finn. It's nice to see you.
I think so. Thank you.
Could you please, I know that you had raised some additional concerns after the public hearing. Does this amendment address those concerns to your satisfaction?
That's difficult to say. I did submit a memo, which I hope you received, that expressed some fairly significant concerns with the original bill. It's the district court judges who apply this law. This is a very important matter, the civil mental health commitment of individuals. I did not receive the amendment, until this morning. I did send it out, but the judges are on the bench all morning, and I have not heard back from them. It's certainly better, much better actually, than the original draft, but I cannot give the judicial branch seal of approval without speaking to the actual judges who have to apply this law, and I have not had an opportunity to do that.
Thank you. That was helpful information as well. Committee members, let's see, are there any other questions for either Dr. Miller or Ms. Nato or Ms. Finn? Not, go ahead, Representative Moriarty.
Actually, I have no questions, but a suggestion as to where we go from here.
Why don't you go ahead with your suggestion, please?
I suggest that we consider tabling this for two reasons. Number one, so that we have an amendment on paper which incorporates all of the changes and can actually read it and see it easily. And that we give Ms. Finn an opportunity to consult with the members of the bench most impacted and get their assessment on the final amendment. That's not a motion because I never want to make a speech and cut off debate.
Thank you. Can other committee members weigh in on whether you would like to debate or whether that the tabling is satisfactory to you? I personally think it's a good idea. Representative Evangelos?
I think it's a good idea too, but I'm ignorant of the law in this area. So if we come back in work session, I'd like somebody to just clarify my mind around the differences between, an insanity defense or a mental illness defense, which kind of, results in this process. I just want to know where we are with that process legally and how this bill fits into that, because I'm not educated on the topic, and I could use some instruction on that. You hear all the time different states where somebody asserts an insanity defense. This seems to be a sort of a preemptive insanity defense where you're not going to face the music in court. You're going to be placed in an institution involuntarily. So if somebody can weigh in on that in the next work session, I have no opposition to tabling. Thanks for that.
Thank you. Representative Harnett?
I was just going to offer a motion to table for the reasons stated by Representative Moriarty, so we can see the amendment with the newly incorporated language recommended by Ms. Neto and seemingly agreed to by Dr. Miller, and to give the Judicial Department a chance to reach out to the judges most affected by these changes.
And is there a second?
Second.
Seconded by Representative Moriarty. And if everybody who is present could please activate your camera so that we can vote on this. All right. We had done this before with a show of electronic hands, and let's do that again, please. This is on the motion to table. And then I'll just check in. Senator Keim, are you available to activate your camera and vote? I think she's probably been pulled away on other business, so.
I get 9. Did I count wrong?
I think it's just 8 because I think that Senator Keim has had to step away.
I'm missing some. Who else is absent? I have Senator Keim as absent.
Okay.
Sorry.
Yeah, so it's
I'm doing the math in my head. I have 5 absents. There must be a 6. Oh, Laurel's not here either. I'm sorry. Representative Libby. Thank you. My apologies.
It's okay.
6.
Just for the record, we've had a storm here for 2 hours and a significant snow cover right now. So it's coming for you folks.
Thanks for the weather report. Okay, so that closes our work session on LD 861, and on LD 747. And now we'll move on and open the work session on LD 1096. And I forgot to take my hand down. LD 1096 is an act to clarify the rulemaking authority of the Supreme Court regarding electronic records and filings. And Peggy, if you can give us kind of a summary review of the bill analysis, we'd appreciate it.
Sure. So the statute authorizes or recognizes that the Supreme Judicial Court has rulemaking power over any kind of rules, regulations, orders governing the administration of the judicial branch and all the proceedings in the judicial branch. And in the bill analysis, I included all the provisions in the statute where it says, after the effective date of the rules as promulgated or amended, all laws in conflict shall be of no further force or effect. And what this bill does, it amends section 8C of Title IV. And these rules were mainly about e-filing, turning into an electronic filing system, record system, and it authorized the Supreme Judicial Court to adopt by rule anything dealing with processes or procedures to track preservation, disposition, integrity, anyway, dealing with all those records and with electronic records. And when that was enacted in 2015, it didn't include that effective date. After the effective date, whatever laws are in conflict aren't in force anymore. So that's what this bill does, is it just clarifies that the rules about electronic records are still, the Supreme Court really is still in charge of all those, even if there's a former statute that deals with, that is in conflict. That was way too many words, sorry.
Thanks. And just to clarify, that's a common provision that's found in multiple other parts of the statutes.
Yes.
Okay, thank you. Representative Babich, did you have a question, or is that a residual hand?
Oh, sorry, it must be residual. Sorry about that.
Representative Reckitt, go ahead.
Well, excuse me. I wanted to, given that there was no opposition to this bill in hearing, and neither was there anybody, neither for nor against, I'd like to make a motion to ought to pass.
Thank you. We have an ought to pass motion. Is there a second? Seconded by Representative Arnett. And then discussion on the motion. Representative Moriarty, your hand is up. Did you want to speak?
Very quickly, Madam Chair, I think we're actually poised to pass this 2 days ago, but Representative Libby pointed out to us that there were a number of people or members absent, and that the vote might not be as decisive as it would be if there were more present. So for that reason, I think there was a suggestion that we go to work session that same day, but we elected to stick with the schedule knowing that it was coming up 2 days later.
Mm-hmm.
So we now have more people, and I agree that the motion is appropriate and we should go forward.
Thank you, Representative Moriarty. And I did want to point out to the members of the public that those who are not present at this meeting are able to cast votes until the second business day after today's meeting. And so that would actually, that gives those who are not present 5 days to look at the bill and think about it and cast votes if they're interested. We had two hands up. Representative Reckitt, is yours residual or?
No, I'm a residual hand. Sorry about that.
Sorry, though we're using all these weird words right now. Representative Thorne, go ahead.
Thank you, Madam Chair. I apologize for having to ask this, but I had a Sophie 911 and missed the last few moments. Where are we on this current motion?
So it was a motion by Representative Reckitt and a second by Representative Arnett ought to pass, since it's just a routine technical change.
On
1096. This is the resolving if there's something that was missed in the statutes after implementation of the e-court system, that the rules related to the electronic filing would prevail.
Thank you.
You're welcome. Other questions? Not seeing any. Thank you, Ms. Panett. We are ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim, Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan. Representative Libby. Representative Poirier. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Keim. Excuse me, Senator Keim. Senator Keim is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Madam Chair, I have 8 members voting in the affirmative, 0 members in the negative, and 6 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And so that we will bring to a close our work session on 1096. And we have 9 minutes before our promised adjournment time. And we have a couple of bills left. I'd like to turn our attention to LD 887. That is an act to require uniform adherence to Internal Revenue Service guidelines by Maine nonprofit organizations. And it's there was an amendment. Actually, I think I'm going to turn it over to Peggy.
Sure.
We're opening the work session on 887, and we'll see if we're able to complete our work on this today. Go ahead, Peggy.
Great, thank you. So LD 887 is a concept draft, an act to require uniform adherence to Internal Revenue Service guidelines by Maine nonprofit organizations. It was a concept draft, but the sponsor asked for a quick amendment to bring to you to try to focus what needed to happen. And the amendment was proposing that the Secretary of State review and make recommendations regarding adherence to IRS guidelines for nonprofits. The Secretary of State is involved only to the extent that they're a filing office. So if you're a nonprofit that is registering in this state, you're incorporating in this state, you do that by filing your articles of incorporation with the Secretary of State, and then you have an annual report that you need to file every year. And the really neat thing is you can go to their website and you can look up every nonprofit and see if they're in good standing. And good standing is submitting their reports, and their reports have to include certain information. But the Secretary of State doesn't review those or any internal operations of the nonprofits. I did share this amendment with Kathy Bodwin and Secretary of State Bellows, who magically appeared. And the Secretary of State did provide you with some written testimony. I don't know that if you saw that, and I think it's posted online in the electronic LD file. I also touched base with Maine Revenue Services just quickly to confirm that the nonprofit status is really established at the federal level, and their tax exempt status is established at the federal level. So there's not really any oversight that our Maine Revenue Services undertake in that type of determination of whether somebody is tax exempt. I'm done.
Thank you very much, Peggy. That was a speedy and clear synopsis. Representative Moriarty, your hand is raised. We also have the Secretary of State present, and I wanted to just give her a moment to speak with us regarding her. Is that okay with you?
I'll defer. Sure.
Thank you very much. Welcome, Secretary of State Bellows, back to your old committee. Have you brought us treats that you can transmit to Secretary?
When you meet in person, I will bring you treats. So noted that I have a debt to the committee. It's a pleasure to be back before Judiciary. Thank you, Senator Carney, Representative Harnett, members of the committee. I won't read the entirety of our submitted testimony because I recognize you're short on time, but I did want to clarify that our office is ministerial or administrative. We have no investigatory or enforcement authority when it comes to the nonprofit and for-profit corporations that file with us. So should you decide that you would want us to take on this role, that would require putting in place a new investigative division and then a hearings division to allow for due process of those that we would be investigating. So that would be a significant change to the mission of the office, our mission really being about corporate transparency and, to Peggy's point, making the information available that people can review. But we don't have the expertise or the staffing that could conduct investigations and then conduct enforcement.
Thank you very much. I'm going to turn to committee members and see if committee members have questions for you. Go ahead, Representative Moriarty.
I move on not to pass.
Okay, is there a second to that motion? Seconded by Representative Newell. And Secretary of State Bellows, thank you for being here. I think that we all understand your testimony and your perspective. And so I'm going to send you back to the attendee space and look forward to getting treats from you in the hopefully not too distant future. Thank you. Okay, committee members, is there any additional discussion on the motion? I am not seeing any, so I think we're ready for the vote, and Ms. Panett is here. Thank you very much, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan. Representative Hagan. Representative Libby. Representative Poirier. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Poirier. Representative Poirier is absent. Representative Thorne. Representative Thorne is absent. Madam Chair, I have 7 members voting in the affirmative and 7 members are absent. Excuse me, 0 in the negative and 7 are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. So the motion ought not to pass motion carries. And we are, I think, seconds away from our 12:30 adjournment time. And committee members, is there any final business before we adjourn? Representative Thorne?
Thank you, Madam Chair. It get kicked off Zoom before I could vote on the last one. Didn't know if I could vote.
Yeah, I think that's appropriate. I'm sorry about the technical glitch. Go ahead and cast your vote.
I vote nay.
Thank you.
Thank you.
And
I'm sorry.
could you tell us what your report is?
Ought to pass?
You mean ought to pass with the amendment that Representative Stearns offered?
Yes.
Thank you very much. I'm glad you were able to return.
Thank you.
Committee members, is there any final business before we adjourn? Does not look like it. I just want to express a lot of thanks to everybody for working so hard and so focused today. We really accomplished quite a bit. I see a whole bunch of hands up now. Representative Reckitt was first, and then Representative Thorne, and then Representative Evangelos.
Could you just tell us quickly which ones we either tabled or never got to on this list we have?
We
today?
did not reach our final bill, which is 461.
Right.
And then I believe that we tabled 785 and 861.
And 747 because you wanted to see the amendment.
Thank you.
And let the judicial branch weigh in.
Thank you. And 747.
Thank you very much.
Thank you. Representative Thorne?
Thank you, Madam Chair. My question was for Peggy. Just for my notes, the vote on the last one, 887, the yeses and absence.
Right. I believe it's 7-1. Soupy will correct me. 7 in favor of the ought not to pass. You're the one vote ought to pass as amended. And then there were 6 absent.
Thank you.
She's nodding.
Thank you. And then Representative Evangelos?
Thank you, Madam Chair. Just a closing comment. I think the carrot and the stick worked pretty good today. I'd like to suggest you use the 12:30 method more often.
Thank you. Is anybody else's stomach grumbling? I keep worrying that my computer is going to pick it up and broadcast it. Now I've revealed it to everybody on YouTube. But all right, everyone, is there a motion to adjourn?
So
moved, Madam Chair.
Thank you, Peggy and Soupy, so much.
Have a good weekend, everybody.
Take care.
Remember, Monday's my birthday.
Next week is full of public hearings, so get your chocolate covered coffee beans.
Good suggestion.
Thank you, everyone.
Have a
All
good
right.
weekend.
Take care. Well done.
Take care, folks. We'll see you later.